We are live.
All right, we're live, back on. You can do your report out now.
Okay, I want to reconvene the closed session to open session at 7:15. And if Mr. Gina would do the report out, please.
Thank you, Mayor. The Emeryville City Council and the successor agency met in closed session on the items listed on the closed session agenda. Regarding item 5.1.1, an update was provided and direction was given. Regarding item 5.1.2, an update was provided. On item 5.2.1, an update was provided and direction was given. On item 5.2.2 through 5.2.8, an update was provided. On items 5.3.1 through 5.3.12, an update was provided. Regarding item 5.3.13, a motion by Vice Mayor Martinez, seconded by Mayor Pats, and a 5-0 vote, the council voted to reject this claim. On item 6.1.1 and 6.1.2, an update was provided. That's the conclusion of my report. Thank you.
And with that, at 7:16, we stand adjourned. Okay. And bear with me as I open up the successor agency meeting. City Clerk, are we ready to go?
Yes, Mayor, thank you.
Okay, so I will at this time call to order the successor agency regular meeting. It is still April 7th. It is 7:17. And let me read my quick spiel here. I would like to state for the record that this meeting is being conducted by teleconference pursuant to the Brown Act waivers provided for under the Governor's executive order in response to the COVID-19 state of emergency. During the public health emergency, City Hall is closed to the public. The agenda states that the public may view this meeting as being live streamed online and on ETV Channel 27 and provide comments by submitting an online comment form, which will be then read into the record by staff. The comment form can be accessed by going to our main City of Emeryville website, www.emeryville.org, and clicking on the council agenda and videos. Once there, you will see a link entitled Submit an Online Speaker Card. Okay. And should we do a roll call?
Yes, one moment. Councilmember Bowders.
Here.
Councilmember Donahue.
Here.
Councilmember Medina.
Here.
Vice Mayor Martinez.
Here.
And Mayor Pats.
And I am here. So I'm going to make a motion to approve the final agenda and look for a second.
Mr. Mayor, I'd like to...
second. This is Medina.
Speak into the microphone.
I heard Member Bowders first, so I'm going to go ahead with a motion.
I was going to request
something
from consent. I don't know if you want that now or at consent.
Oh, never mind.
This is for the successor agency?
Oh, I'm so sorry, Mr. Mayor. I second your motion.
Well, now I'm going to give it to Member Medina. So with that, City Clerk, you have a motion by myself and a second by Member Medina, and for approval of the final agenda.
Councilmember Bowders.
Roll call vote.
Yes.
Councilmember Donahue.
Yes.
Councilmember Medina.
Yes.
Vice Mayor Martinez.
Yes, and I will refrain from calling that petty.
And Mayor Pats.
And I'm a yes as well. It's not petty. She was making a motion. He was not. So, and with that, do we have any ex parte communications for this item on the successor agency, Member Donahue? No. Member Bowders?
No.
Member Medina?
No.
And Vice Mayor Martinez?
No, Mr. Mayor.
I have none. And for that, we move on to the consent agenda. And so for that, we're going to have public comments. And so now is the time for public comment portion of this meeting. Anyone who wishes to make comments related to items not on the agenda or on the consent agenda should have submitted your online speaker card by now. 3 minutes will be allowed for the city clerk to read your comments into the record. At this time, I will ask the city clerk whether any comments have been received via the online comment card, and if so, to please read them aloud.
There are no comments for this portion of the meeting.
Great. And so with that, I will look for a motion to approve the consent calendar.
I move to approve all but 10.8. I'd like to pull 10.8.
Okay, so we are still on the successor agency, and so I have a motion from Member Medina, and I will second it. And for that, I will do a roll call on the consent calendar for the successor agency.
Councilmember Bowders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats.
Aye. We have no action items, and now we will take an adjournment. So the successor agency is now adjourned. City Clerk, are you ready?
One moment.
That's why I asked. Good.
Okay, ready to go. Thank you.
No worries. Okay. I will now call to order the April 7th regular council meeting. I have 7:22 on my computer, and I need to read something really quickly. I would like to state for the record that this meeting is being conducted by teleconference pursuant to the Brown Act waivers provided for under the governor's executive order in the response to the COVID-19 state of emergency. During the public health emergency, City Hall is closed to the public. The agenda states that the public may view the meeting that is being live streamed online and on ETV Channel 27. They may provide comments by submitting an online comment form, which will then be read into the record by staff. The comment form can be accessed by going to our main City of Emory website, www.emeryville.org, and by clicking on the council agendas and videos. Once there, you will see a link entitled Submit an Online Speaker Card. Okay, I suspect people want to change the agenda, so I'm going to go to Member Bowders to make a motion on this, and then make sure we get Member Donahue's other change.
Mr. Mayor, I would make a motion to approve the agenda, pulling items 10.5 and 10.8 for discussion.
Okay, Member Donahue, that includes the one you mentioned, but can I look to you for a second?
I second.
Okay, so we have a motion by Member Bowders and a second by Member Donahue. Roll call vote, please.
Councilmember Bowders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats.
Aye. Okay, and with that, we'll go on to special orders of the day. We have none today, which saddens me. Announcement of the commission and committee vacancies. City Clerk, if you will make the announcement.
Yes, thank you, Mayor. We'll begin our annual appointment process for community advisory committees, and we are currently reaching out to the incumbents whose terms end on June 30th to find out whether they're interested in reapplying for continuing terms. And once we gather that all information, we'll know how many potential vacancies we'll have, and we'll be posting an official notice for committee vacancies on Friday, April 10th, this coming Friday. Applications will be due on Monday, May 25th, and appointments are scheduled for a special city council meeting on June 16th. Thank you.
And I'm going to refer people to our website about these vacancies. That was not the most. It's the first time a call has not been so super clear, but I think you were on speakerphone. So again, we do have the committee appointments coming up, so please do check the city website. With that, I will go to council member special announcements, reports on meeting they virtually attended, and I'll start with you, Member Bowders.
Thank you, Mr. Mayor. I have none.
Great. Member Donahue.
I have none.
Member Medina.
None. Very lonely.
And Vice Mayor.
Thank you, Mr. Mayor. I have done a few regional meetings via Zoom, and at East Bay Community Energy, we have decided to redirect some funds that were going to be spent in the very near future on local business development, which we're unable to spend, into grant programs for aid. So if anyone has any nonprofits that they'd like to direct my way, I can direct them to East Bay Community Energy in that application process. And the way to get in touch with me is through my city email address, which is bmartinez@emeryville.org.
Great, thank you. And I'm not going to list all of the meetings I have participated on. I think there's a daily update that I have participated on. And I do want to take a moment and thank Barbara Lee for reaching out to us to check in and see what Emeryville needs during this time. And she was advocating for our community, not just our town, but our community. And I do want to appreciate for her for that. And I want to also thank Nancy Skinner and Buffy Wicks, who joined me on a private conference call between the three of us, again, to just reach out and see how we as a town were doing. And I really do appreciate that. And so those meetings are ongoing, and they are very interested. Congresswoman Lee is also very interested on an item on our agenda this evening when we talk about what we are doing for our renters. So with that, I will go to the city manager's report.
Thank you, Mr. Mayor. I just want to give a gigantic shout out to our city clerk, who has been keeping the website updated more than daily throughout this incident, and also to the entire city staff, many of whom are working remotely and keeping the work going as we provided an update to you last week. And then finally to our colleagues in the police department who are currently still working 12-hour shifts to keep the community safe. And that's all I got.
Thank you. I appreciate that. You know, I do want to second that the city website has been wonderful, and I do appreciate community services presence on social media. And if you haven't seen their virtual recreation, I do recommend you check it all out. It has been great. With that, we move into ex parte communications. Member Donahue, Member Bowders, any ex parte communications?
Thank you, Mr. Mayor. I had conversations with about a half dozen residents, as well as members of the East Bay Community Law Center and Centro Legal de la Raza and Causa Justa for item 10.5. And I had conversations with on item Bike East Bay on item 11.2 and on item 12.1 and 12.2, the same contacts that I discussed at item 10.5, as well as staff from Destination Home in the city of San Jose. And I had conversations with the state senate about item 12.3.
Okay, thank you. Member Donahue.
I had a lot of emails about consent 10.5 and by extension 12.1.
Okay, thank you. Member Medina.
Yeah, for item 10.5, I received those emails to the part of the public record. For item 11.3, I had a conversation with Kevin Casey of New Avenue Homes. For item 12.1, I discussed with San Jose staff, and 12.2 with Berkeley.
Thank you. Vice Mayor.
I received emails on item 10.5 and item 12.1, and those should all be in the public record.
Yes. Thank you. I've had several conversations with residents on those same items, and I think I've mentioned the other people I have spoken with. And so as we go on, we are now to the public comment section. So, public comment. Now is the time for public comment portion of this meeting. Anyone who wishes to make comments related to items not on the agenda or on the consent agenda should have submitted an online speaker card by now. 3 minutes will be allowed for the city clerk to read your comments into the record. At this time, I will ask the city clerk whether any comments have been received via the online comment card, and if so, to read them aloud.
Yes, Mayor, there have, and please confirm whether you all can hear me well. I know there have been some problems with me being heard well.
This time you sound very clear.
I can hear you.
Okay. All right, thank you. I do have 3 public comments that I received. This first one is for item 10.3, and I'm going to time myself, which is weird. Okay. This comment is from Brian Donahue about 10.3. A cannabis retailer wants to expand his business next to the Emeryville Greenway, but there's a problem. It's illegal. However, the idea that cannabis sales can be made too close to public parks, including greenways or religious institutions, has always been fatuous and capricious. Laws need to be rationally based and measurable, and this existing law in Emeryville was never justified and therefore is an example of government overreach. This part of this law is absurd and needs to be stricken from the municipal code. There is no rational reason given that parks and cannabis sales are incompatible. Having said this, I must say how Emeryville that you are considering liberalizing this law now that a business is being constrained by it. There was a time a year or 2 ago when you all thought this law forbidding cannabis next to parks and greenways was ducky. Now suddenly you want to change it and let freedom ring. The old adage about our town applies again. The business of Emeryville is business. It was a phrase offered up by Councilwoman Nora Davis whenever she was prepared to turn public policy away from citizens' benefit to the work of helping businesses in town. At least City Hall is consistent. Rule-backed council members or not, business is still king in Emeryville. And the next one is for item 10.5. I'm not exactly clear of the name of this person, but they say that they are an Uber driver and are not driving now, and their only comment was rent, or rent amount. So that is related to 10.5. And the last one, also on item 10.5, is from Mark Janowitz. Dear council members, I write to urge you to pass the temporary moratorium on residential and commercial evictions on your agenda for this evening's meeting. I'm a housing attorney working with the East Bay Community Law Center in Berkeley. In my work, I assist low-income tenants. Obviously, in the current public health emergency, all tenants, regardless of income or whether residential or commercial, are in very difficult situations. As you know, huge numbers are suffering income reduction or loss. Your proposed emergency moratorium addresses these conditions. However, I urge you to look further and deeper into the ramifications of your proposal. We need to protect all tenants facing eviction, regardless of the reason for eviction. For example, we know many tenants are caring for loved ones. If the tenant is at the home of the other providing support and property manager believes the tenant now has a prohibited new roommate, eviction must not be allowed for the stated ground of breach of lease. That will worsen the public health emergency we face and result in greater peril for the entire community. There are numerous other examples of tenants who need protection beyond those who cannot pay rent. The other major issue concerns repayment of the moratorium-related back rent. Housing providers are entitled to, and in most cases, rely on their rental income. However, if the moratorium results in tenants owing a huge sum of back rent at some point in the future, which results in eviction for non-payment, we have failed in our overarching goal of minimizing displacement. Your proposed resolution approaches a solution. Another proposal is a city fund to assist tenants with back rent as a grant. If the municipality lacks the resources for such a plan, I urge council to pressure officials at the state and federal levels to provide mortgage relief to owners, which relief goes directly to pay tenants' rent. Obviously, tenants pay rent. Rent pays mortgages. If government relief packages go to banks, you must urge inclusion of provisions that the banks transfer their benefits to owners and down to tenants. The goal is to minimize displacement, which injures the entire community. No one benefits. Please consider options to enhance your moratorium proposals with these goals in mind. Thank you for your work in public service.
Thank you. Okay. And Sherry, I'm going to look to you for some help here. Do we do the pulled items first or the whole remaining agenda?
You would do the items that you're keeping on consent and then do the 2 items separately for separate consideration afterward.
Okay, so I will look for a motion and a second on the consent calendar.
I move the consent calendar.
Second.
Great. And I'll go ahead. Great. So we have a motion from Member Donahue and a second from Member Medina. A roll call vote on the consent calendar.
This is on the consent calendar minus items 10.5 and 10.8. Councilmember Bouders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats?
Aye. Okay. 10.5, an ordinance to the City Council on the moratorium on the residential and commercial evictions. I believe, Member Bowders, you wanted this one pulled, so I will move to you.
Thank you, Mr. Mayor. I would ask if staff could put the red line that I have proposed that I sent most recently, the one that didn't have the typo in it.
One moment while I pull that up.
Thank you.
Okay.
PPT.
I believe it's this one. You'll tell me.
PPT presentations, and it's the land. Yeah. There you go.
Can everyone
Thank you.
see that?
This is the correct one. Thank you. So, Mr. Mayor, there's been a number of comments that all of us have received from the public, and I want to open my comments on this by thanking the city attorney and the assistant city attorney. We have spent a lot of hours together in the past 2 weeks, both on the initial draft, which we all discussed as an urgency ordinance, if you recall, about 2 weeks ago, and then the time that has been spent in between. And Section 6 has been a particularly challenging section for me, partly because the language we approved last time was based on the best guidance, which I receive wholeheartedly from the city attorney, related to what the scope of the governor's executive order N2820 authorized cities to take action on. And so the original version that we passed contained 2 provisions, which are the strike-throughs here in this section. One of them was to distinguish failure to pay rent from other causes for termination. And there's kind of a balance to be had here. There's, on one hand, there, as have been noted in public comment, many people for whom the non-payment of rent is not the reason for which they may be evicted. I have followed closely in the news, as I'm sure you all have, people who have seniors at home whose children have been sent home from college, and they do not want the student coming home from a dormitory or from a spring break even returning into the home where a parent or a sibling who's immunocompromised or a senior who lives in the home with them entering the home, and that has left many college-aged people in particular in situations where they are residing with other people in housing for which they are not on the lease. This is just one of several examples where people could be subjected to evictions for issues that are not non-payment of rent. That cuts against other issues and concerns that cities would have. For example, if somebody was operating a meth lab in an apartment building in the city, it would not follow that we would want to prohibit all evictions in the city if there were threats to the well-being of other people who are actually currently obeying the state's orders to shelter in place. And so I know the city attorney is going to opine on this, but a lot of time has been spent in the last 24 to 48 hours since this draft was released between himself and myself going over this language, and I have consulted with a number of fellow tenant attorneys, and I am proposing that we do two things on this item. One is that we approve at first reading a revised version to this ordinance with the following change that removes the distinction between non-payment of rent and all other cause evictions, and simply says that during the term of this ordinance, a landlord may not terminate the tenancy of a residential tenant or residential tenant household, except upon a showing by the landlord that termination of a tenancy is necessary to protect health, safety, or welfare. This, I think, is the best way to accomplish the goal of protecting people across the city, and I would urge us to not only pass this at first reading tonight, but then to ask for an identical version of this ordinance to come back at the next meeting as well as an urgency item to be passed consecutively at the second reading. In the meantime, the current ordinance that we pass as an urgency ordinance still remains in effect, so nobody is losing protections. With that, that would be my presentation. Thank you.
Great. Okay, Member Donahue, clarifying questions?
No, that seems very reasonable.
Okay. Member Medina, clarifying questions?
No.
Okay. Vice Mayor, any clarifying questions?
No, Mr. Mayor, thank you.
Okay. I have no clarifying questions. You did mention that the city attorney was going to opine, and so, Mr. Dina, did you wish to speak now?
Yes, thank you, Mayor and Council.
Okay, before you do,
okay.
if you, I will go to you in just 1 second. I just want to remind the public that may be watching at home, I will take public comments on this because I do think this is really very important, and so do submit any public comments online, and this will be your opportunity. Go ahead, City Attorney.
Thank you, Mayor. Councilmember Bowders and I have spoken about this item, and my recommendation to the full council is that we do not adopt the amendments as proposed by the council member. And the reason for that is the basis upon which the council had adopted the current urgency ordinance, which was based on the governor's order EON 2820. And the governor's executive order provided for a moratorium on evictions, specifically for non-payment of rent. And so based on that authority, the council had adopted the current urgency ordinance to be in line with that executive order. And so that provides us with additional legal protection in case that our urgency ordinance is challenged. What the ordinance amendment that Councilmember Bowders is proposing goes beyond the scope of the governor's executive order and exposes the city to litigation for claims that where we would not be able to rely on the executive order and the protections of that. The urgency ordinance also talked in the purpose and scope of the urgency ordinance. The council had also adopted. You had also tied the adoption of that urgency ordinance to issues relating to non-payment of rent. And so for those reasons, I cannot support this item and would recommend that the City Council not adopt it.
Mr. Mayor, may I respond?
Please.
Thank you. Again, I really appreciate the city attorney's advice, and I'm not here to have a public debate per se with him. We've worked very collaboratively on this, and I think it's fair to say that all of us wish that the state of California, either the governor or the legislature in an emergency session, were to take more decisive and clear action to provide guidance and uniform application of protections to tenants across California. The legislature gave the governor the authority to do this. The governor, I believe, has not taken adequate steps to protect tenants, and that has left cities creating questions like this around whether the executive order limits our ability to do things or whether we would be essentially superseded by anything that the governor has done. I haven't been able to share all the case law with the city attorney, but I would just share with my colleagues that years of practicing as a tenant attorney is not a substitute for the advice the city attorney gives us, but there is case law in California that addresses the concerns he has. Both the Allied Structural Steel versus Spanish case discusses the fact that the state police powers and the ability of local governments to engage in police powers allows for the abridging of a contractual relationship like a landlord-tenant one, provided it's for a legitimate and limited purpose. And in the case of Berman v. Downing, the city of West Hollywood, which is a general law city, in 1985 actually put 6-month limited restrictions on rent, both restricting the amount of rent that could be charged, retroactively moving rents and rolling them backwards to what they had been before the city had incorporated the year before, and also providing relief for tenants. And a landlord sued tenants to try to enforce a higher rent, and the court ruled that in an emergency situation, as one was declared in the city of West Hollywood for a housing crisis, as long as the efforts that are taken by the jurisdiction are limited and they are to the subject matter and not to the process, that those things can be done if they're tied to a legitimate purpose. Health, safety, and welfare are all listed in the scope of this ordinance in Section 2, and I've listed them as the reasons a court could grant relief here. So a landlord who needs to obtain relief is not prohibited from doing that, and I think that given the current circumstances, a court would find in our favor if there was to be litigation, which I don't suspect would happen. So I know the city attorney has not had the benefit of reviewing the case law that I have due to the timeline we've been working under. But with that, Mr. Mayor, I know you'll take public comment, and I'm going to just put on the table a motion to approve this as amended.
Okay. And so thank you for continuing that segue. Please do.
Okay. I heard.
This is Member Donnie.
I heard news a couple hours ago that the county, and I just heard this on the radio. The county amended something about this, saying that eviction for any cause was going to be suspended. So they were strengthening at the county level, is what the news said. Has anyone else heard anything about that?
I'm going to look to, I have not heard that. I'm not hearing anybody speaking up saying they have heard that. I think that would be wonderful if they did that. That has not occurred at that time. At this time, I am going to ask the city clerk if we have any comment cards on this item.
We do, yes.
Go ahead.
Okay, this comment comes from Shaylin Wells. I am a tenant attorney at East Bay Community Law Center, an organization that serves tenants in Alameda County. I'm asking that the COVID-19 rental eviction ordinance be amended and passed. While I appreciate the work of the City Council thus far, I am concerned that many Emeryville tenants are still left unprotected during the crisis. This is more than just a tenants' rights issue. People who do not have a home cannot shelter in place. An influx of people on the streets is a threat to everyone's health and safety right now, not just the tenants who stand to lose their homes. Given the severity of this pandemic and the governor's shelter-in-place order for the entire state of California, what action will be taken to ensure that Emeryville residents can meaningfully comply with shelter-in-place during this pandemic? We are looking to the City Council and the City Attorney tonight to protect Emeryville residents. The moratorium should apply to all evictions, not just evictions for non-payment of rent. Oakland and San Francisco have already done this. As the ordinance is currently written, a landlord could evict a tenant during the pandemic for the tenant's decision to move an elderly parent into their unit and them to provide care because unauthorized occupants are a violation of the lease. Failing to halt all evictions runs contrary to the statewide shelter-in-place order, public health guidelines, and the City Council's responsibility to protect all of your constituents. The moratorium should specifically address and invalidate eviction notices served on or after the date that shelter-in-place was ordered, and on or before the date this moratorium passed, and eviction notices served during this moratorium or that were served prior to the moratorium, but have not yet expired. The moratorium should not allow tenants to be evicted for back rent that accrued during the state of emergency. Any and all rent accrued during this moratorium should only be recoverable via small claims or regular civil action, not unlawful detainer. And this rent should only be recoverable after the landlord has attempted a reasonable repayment plan and provided tenant written notice of this ordinance. Proceeding without such a protection will facilitate avoidable homelessness. Please amend and pass this ordinance. Thank you. And that is the last comment I have for now.
Okay, so we'll move into discussion. Normally I would start with Member Donahue, but since he had the last question, I'm going to move to Member Medina.
Thank you. And sorry, I didn't unmute in time to ask my question prior. I guess this is for the city attorney. Does the Judicial Council decision from, I guess, yesterday, that temporarily suspends courts moving evictions, does this apply to all evictions or just for ones related to non-payment of rent?
It applies to, so you're talking about Judicial Council Emergency Rule Number 2, suspension of action for judicial foreclosures. And so it applies to all actions. It does not specify, it doesn't limit it to a certain type of foreclosure.
To be clear, Mr. Mayor, I'm sorry. To be clear, emergency rule number 1 relates to evictions, and it actually provides all evictions.
I'm sorry, can you say that one more time?
Judicial Council Emergency Rule 1 was adopted yesterday unanimously by the Judicial Council, and it essentially, the action that it takes, and I have it on my desk because I do it in my full-time job. Give me one moment. I will pull it up for you. And it says that notwithstanding any other law, including Civil Code Procedure 1166, a bunch of relevant circumstances, a court may not issue a summons on a complaint for an unlawful detainer unless the court finds in its discretion and on the record that the action was necessary to protect public health and safety. It does not distinguish between non-payment or other forms of complaints for cause. It's for all evictions.
So, okay, thank you very much, Councilmember Bowders, for that clarification. So back to the city attorney, Mr. Gina, would that mean that whether or not we take this amendment, de facto, no evictions will be processed for anyone except for in the basis of public health and safety during this time period in Emeryville?
Correct.
Is that correct?
Yes, that's correct.
Okay, so that's really helpful. So my concern had been, okay, if we don't do this tonight, there is a possibility that we're leaving the door open for someone to get evicted for, a reason like that. Perhaps they're trying to shelter a family member who needs a place to shelter in place during this. But that is not the case. Nobody would be evicted in the next 2 weeks if we spend some time delving into the legal issue.
I'd like to raise an issue.
Sure.
I will come back to you in just a minute, Member Bowders, but I want to give the Vice Mayor and Member Donahue a chance to speak, and then we'll come back to you, okay? And at some point, I want to also give the City Manager a chance to speak. So I'm going to come to you now, Vice Mayor.
My ears are still open. I want to hear what everyone has to say. In the meantime, all I can find from the on the Alameda County Board of Supervisors action is an approval on an urgency ordinance providing a temporary 30-day moratorium on evictions in unincorporated parts of the county. So if Member Donahue has access to any news that talks about the entire county, I would love to see that. If you could share that with staff to share with the rest of the council. I generally am in favor of strengthening these protections for tenants, but I'd love to hear more from Member Bowders as our resident expert on tenants' rights.
Thank you. All right. So, Member Donahue?
Well, I'd like to hear what John has to say, having heard everything.
Great. Thank you. Okay. Member Bowders, I'm going to come to you, and then City Manager, I would like to hear from you as well. So, Member Bowders?
Thank you, Mr. Mayor. In response to Councilmember Matina's questions, it is not the same. I want to clarify the process. The Supreme Court, the Judicial Council's rule, Emergency Rule 1, says that a court may not issue a summons. So what that has the practical effect of doing is it stops it at the time in which a complaint is filed. That is not where we want eviction protections to be, and that's the same faulty mistake, like an error that the governor has used in saying that there is an additional 60 days to provide an answer. The problem is that there is a court action already initiated. So the reason our ordinance says that they cannot terminate a tenancy, they cannot issue a notice. And the reason that matters is because under housing law in California, the notice period is the only period of time legally that you have an opportunity to cure a defect as alleged in the notice. If I, as your landlord, serve you a 3-day notice and say you owe me $1,000, you only have those 3 days to cure the defect. The only defense you have to non-payment of rent is to pay it within the 3 days. If the 4th day comes or the 5th day comes, the landlord can go file a complaint. Even if you remit to me $1,000, I still have a right to get possession of the property back because you have failed to comply with the material term of the lease by paying in time. And so the problem is that these other protections that the state has put into place are inadequate. They're inadequate because they allow for the period of time to pay the rent to lapse. And if we're trying to protect people meaningfully, they don't have the money today. So if landlords are allowed to issue notices today, the 3 days pass, they don't pay the rent, even if we're waiting under the Judicial Council's rules or the governor's rules, even if we wait until this crisis ends and then the summons can issue or the complaint can be answered, the reality remains that unless a landlord voluntarily agrees to enter into a repayment plan with the tenant, the landlord can still evict the tenant. So we're not actually preventing evictions, we're simply staying executions. This provision in this amendment that I'm proposing tonight essentially says you may not engage in that process at all. So the 3-day notice that would go to a tenant won't go until this entire crisis is over, which gives the tenants the time to prepare for how they're going to finance that. And we have another agenda item tonight that would require a repayment plan before they can issue that notice. So we're providing an extension of protection for people after this crisis is over. That's the reason why this matters and why it's not sufficient to rely on either the governor's order or the Judicial Council's protections, because while they slow the court process down, they don't prevent people from being put in the court process to begin with. Thank you, Mr. Mayor.
Thank you. I have several comments on this, but I'd like to hear from the city manager first.
Thank you, Mr.
City
Mayor.
Manager?
Thank you. I think my comment is more of a process comment than a content comment, although I just wanted to note that the ordinance that's before you does actually prohibit, as I understand it, the eviction for non-payment of rent during the term of the ordinance, which was, I believe, what the council member was speaking to, was the non-payment of rent in that example. With that said, however, I do want to appreciate Councilmember Bowders acknowledging that the city attorney has not had the opportunity to review the cases that he was describing earlier in his previous comments. And I would just, I guess, ask the council to consider giving the city attorney, its attorney, the time to review that information and perhaps not conduct the second reading, but carry the item over for reconsideration at the April 21st meeting. I really would ask that you give the team the time to take a look at what's being proposed tonight. And I understand there has been some conversation, but I think I would ask that you give time for that legal review and for memos to be provided for you to consider at your April 21st meeting. Thank you.
Thank you. I think that was very good advice, and I appreciate that. And that said, I am of the mind that this is one of those things where time is of the essence, keeping the public safe is of the essence, and putting these changes in now are critical because, as Member Bowders has said, we're going to do some things to hopefully alleviate the pressures it's going to put on landlords later this evening. And to the city manager's point and the city attorney's questions, I think this is one of those things, it's an emergency order. If we can put it in place now so that in place it takes effect. If we need to revise it, we can. and that is a different process. And so I would argue that we approve these changes, and when Member Bowders makes his motion, I plan to second it with a friendly amendment. Right now, this ordinance is set to expire May 31st, and I would like to amend that to June 30th, because I feel like the closure orders have been extended since we last met, and paychecks and rent tend to come after things, and so I think people are going to need the month of June to figure out where all of this falls. So with that, I will hand it back over to Member Bowders to see if he accepts my friendly amendment.
Mayor Pats?
Yes.
It's Sherry. I'm sorry to interrupt. I wanted to let you know, as a procedural matter, we did receive an additional public comment, but it's from the commenter who previously I read. So it's a second comment on the same matter. And so I just wanted to make you aware that we have it, and I can read it or not based on what you decide.
They had their comment. They also commented at the start of the meeting, I believe. So I'm going to hand it over to Member Bowders.
Thank you.
Actually, Mayor Pop, I actually never got my question answered. This is Member Medina.
Oh, I'm sorry. Please.
Yeah, and I'm just trying to clarify this, and it's hard because we're all on conference call. I understand from Member Bowders that the termination versus the notice and the summons, I get that. And I am fully supportive of saying a landlord should not terminate the tenancy of a resident or residential tenant household. And I think what we're having the discussion about tonight, this red line that's been put up here, is whether or not we should extend that for all other cases except for those necessary to protect health, safety, and welfare. And my question for the city attorney is, if we are already protecting in case of rent for sure, and we wait an extra 2 weeks, will any evictions be able to be initiated for people that are being evicted for reasons other than non-payment of rent because of the judicial council decision? And I did not get the answer from Mr. Dina, so I'd like to clarify that because I think it's a really important point here.
Right. So the if the can I repeat the question back to you so I can make sure I'm understanding it? Or actually,
absolutely.
Would you mind restating it one more time?
Okay. So the urgency ordinance we passed last time.
Yeah.
We have all agreed that a landlord may not terminate the tenancy of a residential tenant or household due to non-payment of rent. The red line we are discussing tonight that would add in another category of people being evicted for not non-payment of rent, but for other reasons except for public health and welfare. And so my question is, because of the judicial council's decision, does that mean that there's any chance in the next 2 weeks that there could be harm caused to a tenant for those other reasons or not? Like, that's what I'm trying to clarify, because Mr. Bowders answered me specifically in the case of rent, but that's not my question. I'm asking about us extending this red line protection to another group of people who are presumably covered under the judicial council for something. I am not a tenant attorney expert, so I'm trying to get clear here, and I'm not sure that all of us are clear on this.
Sure. So the tenant may, the landlord could still initiate the termination of tenancy proceedings. They just would not be able to go forward with the unlawful detainer action because of the judicial council's order. But in the scenario that you've presented, in this time period, in that 2-week time period, the landlord still could move to terminate the tenancy of the tenant.
So say in the case of, let's just use an easy example here, somebody who had a relative who needed a place to stay, shelter with them, even though their lease doesn't allow an extra person to be added, the landlord could begin the eviction proceedings. They wouldn't be able to cure this because they don't want to kick out somebody during the COVID crisis, the shelter-in-place emergency. And so as soon as the state of emergency is lifted, then they would be evicted, if that's possible.
Right. So if when the eviction well, when the emergency is lifted, and then are you saying that at that point, so the landlord would not be able to, or would be able to go forward with evicting, or I'm sorry, with starting the termination of the tenancy, but when the emergency is lifted and presumably the Judicial Council's order is also lifted, then they would also be able to start the unlawful detainer action.
Okay, so that answers my question. So basically, yes. So currently, people who are violating the terms of their lease to help shelter others are at risk right now.
Yes.
Yes.
Okay, that is what I was trying to clarify here, and I'm sorry this is complicated to discuss over the phone.
Proposal.
Okay, I'm sorry. I seem to have lost control here. So I want to go back to Member Medina and say you feel your question is now answered?
Yes, thank you.
Okay. Member Bowders, you were next to speak. Member Donahue, Member Bowders, I'll ask that you don't make your motion so that Member Donahue can speak after you, and then I will come back to you for a motion.
Mr. Mayor, I would like to let Member Donahue go before me. Thank you.
Okay. Member Donahue?
How about we protect our tenants absolutely until our next meeting, April 21st. So, in other words, we take John's language and we say it's good until next meeting, and Mr. Gina does his research. And if for some reason it's just not going to work after that, we can make changes after that. But between now and then, we are protecting tenants.
Okay,
Mr.
thank
Mayor?
you. Member B, yes.
If you could just have the city attorney address the timing of that, because this is the reintroduction of a first reading. If I'm
That's correct. Thank you, City Manager. Mayor, may I?
Please.
So the City Manager makes a point that what is being proposed is the first reading of a new ordinance. So if the Council adopts the amended new ordinance tonight, that would not take effect tonight. The new ordinance would still require a second reading at your next meeting, and then a 30-day period thereafter. Until that time, the current urgency ordinance that you adopted on March 19th would continue. So I want to make clear that if you adopt an amended ordinance tonight, that would not take effect tonight.
Okay, thank you for that clarification.
Okay. So I'm going to go back to Member Bowders now.
Thank you, Mr. Mayor, and thank you to Councilmember Medina for the excellent question. Yes, if you live in a household right now under our current ordinance and you are being evicted for any reason that is not non-payment of rent, such as sheltering another person who's not on the lease, you can receive a notice for which the expiration of that notice would take place now, and they can still go and file the complaint even at court. This simply would not be issuing a summons right now under Judicial Rule number 1, which, by the way, I believe takes effect on the 10th. And to Member Donahue, I appreciate the mindset, which is what exactly my question or my comment was going to be, was that as I opened this item, I suggested that we have a parallel urgency ordinance at the next meeting to correspond with a second reading of this ordinance. That puts both of these on the agenda at the same time. The city attorney has the opportunity to review additional material in the interim. I appreciate all the tasks we've given the city attorney, and my disagreement with him is not a reflection of his understanding of the law. It's simply the sheer capacity and the number of things he's been asked to do in such a short period of time given this crisis. And the mayor's request, in light of my reading of the law, which is that cities can make reasonable police power extensions that interfere at times with contracts, provided they're for a limited purpose and that they apply broadly and generally to meeting that crisis. The fact of the matter is we don't need to be within the ambit of the governor's expiration date of May 31st because we're not operating within that authority. We're operating with an existing case law authority about our ability to exercise our powers. So I would like to withdraw my prior motion and make a motion to approve this ordinance as amended at first reading on the red line, but also to amend the date of May 31st as the expiration of this ordinance and change it to June 30th, 2020. And that's my motion.
And with that said, I'm going to second that motion. But before we take the vote, I want to make sure that every member feels their questions are answered and their comments heard. So before I go to the vote, Member Donahue, do you have any other questions?
No.
Or substitute motions or anything? Member Medina?
No.
Okay, and Vice Mayor?
No, thank you, Mr. Mayor.
Yeah, and I apologize for taking this out so long procedurally, but I just want to make sure that we are all heard and it is challenging in a conference call. With that, we have a motion from Member Bowders, a second from the Mayor, and roll call, please, City Clerk.
Councilmember Bowders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats?
Aye. Thank you guys for that. That was a good conversation. And to the attorney, I do appreciate your work on that. And so that brings us, I believe, to 10.8. Is that correct?
Yes.
Okay. And Member Bowders, did you pull this, or is this the one that Member Donahue pulled?
I
Seems
I
like
pulled
so
it.
long ago.
Mr. Donahue.
Okay. Member Donahue, I will hand it off to you.
Okay, this is has to do with auditing and then collecting on sales tax and offering a contract to a company to do that work. And the monies that they get are a percentage of what they call discovery of miscalculation of taxes due. And they get 25% of miscalculated taxes due. They also get a fee of $625 to look at the records. So my question about this is, sales tax has been our main source of income, and now it's not looking so good to be our main source of income. There's definitely a downturn in our sales tax revenue. We can tell just by looking around us. So is this allocation of percentage of the take from miscalculation and fees correct for this new environment we're in? You know, if I just look at it from the point of view of my youth in Philadelphia, wow, the potential for, different ways of earning money off of this could yield things that are not so great if there's desperation from a collection viewpoint. So it's a question of partly of the city manager, but of other cities having, when there's a different environment, do the terms of this contract make sense in a different economic environment? So it's a question.
Okay, city manager?
Yes, thank you, Mr. Mayor. Thank you, Councilmember Donahue, for asking about this. This contract is being proposed as an extension of our existing services from this same agency. This is a companion item for purposes of the CDTFA contracts that we're required to enter into to collect the new sales tax that the voters approved on March 3rd. And so we already have an agreement with this company to do similar work, and they are the ones who provide us the quarterly analysis of our existing sales tax revenues. And so this would be a companion for the new quarter-cent sales tax that the voters approved in March.
All right, so I can see that, it doesn't amount to very much money, and therefore, it's not as big of an issue as what I was thinking. But still, nonetheless, to the point of my question, going forward, do other cities do anything different than this?
Councilmember, many cities use this same firm, Muni Services. Many other cities use another firm by the name of HDL. It is very common to have an outside agency that does this kind of work, particularly for smaller cities that don't have a fleet of employees who are running around doing audits of businesses and looking at their tax returns. So it is not uncommon to have this kind of a firm. But I do want to acknowledge and appreciate your comments about the changed environment around this particular revenue source for Emeryville, and it is likely that we will be coming back to you in the next couple of months with some significantly revised revenue projections, and we may be looking at a different way of managing these revenues in the next year.
Okay, I don't have any further questions. Thank you very much.
Okay. Member Donnie, I'm going to come back to you for a motion on this, but if anybody has any questions, and Sherry, do we have any public comments on this item?
We do not, Mayor Pats.
Any questions or comments from other council members? Member Donnie, do I hear a motion for approval on this item?
Yeah, I move approval.
And I'm going to second it with the comment that while some retail sales are down, there's a rumor that alcoholic beverage sales are up. So we'll have a windfall on that. So, and I don't think we should do anything to get in the way of that. You have a motion from Member Donnie, a second from myself. Can I get a roll call, please, Clerk?
Councilmember Bouders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats.
Aye. Okay, that brings us to public hearings. The first public hearing is the Affordable Housing Project, and do we have a presentation for the city manager?
That would be Mr. Smalley. Are you
Yes.
on the line? There we go.
Yes, thank you, Mr. Mayor. This is Chad Smalley, Economic Development and Housing Manager. Good evening, Mayor, members of the City Council. I'm going to give you a real brief overview of this item. This project, 3706 San Pablo Avenue, is an affordable housing project. It's been constructed and is in lease up now. And the relationship with the developer dates back to 2012. In 2017, the City Council held this same kind of public hearing. It's termed a TEFRA hearing. That acronym standing for the Tax and Equity Fiscal Responsibility Act, and it's required by federal law when an affordable project uses tax-exempt bonds. Now, the reason we're here again with the exact same project and the exact same type of hearing is that due to construction costs and the experienced and overruns that were experienced during the construction of the project, the developer wants to avail themselves of additional bonds and a longer maturity date. And so that triggers a technical refinancing under the federal law, and so it necessitates another TEFRA hearing. So we've done this before, where the city of Emeryville became a member of the CMFA, which is the issuing agency for these bonds. I want to be clear that these are not bonds it's not the city issuing these bonds. These are not the city's bonds. We have folks on the line from CMFA and from the developer, EAH Housing, if you have any questions about this. But we're asking for, in order to facilitate the closeout of the project, that we conduct this TEFRA hearing, which allows them to get the extended maturity date, and then they can proceed to permanent financing conversion. If you have any questions, I'm here to answer them, as well as Anthony Stubbs from the CMFA or Ethan Daniels from EAH Housing. They're also on the line. Thanks.
Okay, before I go to the council members for questions, I just want to quickly remind the public that in a moment I'll be opening the public hearing. The way you will testify at the public hearing is by submitting an electronic comment on the city website. And with that, Member Donahue, any clarifying questions?
No.
Member Bowders, because my alphabet is messed up now. Clarifying questions. Member Medina, any clarifying questions?
No.
And Vice Mayor, any clarifying questions?
No, thank you.
Okay. City Clerk, were there any public comment? I'm sorry, let me officially open at 8:20 p.m. the public hearing. And City Clerk, are there any comments?
No, there aren't.
Okay, that is my pause for delay. At 8, I'm going to wait a moment, at 8:20 still, we will close the public hearing, and I will look for comments or a motion, starting with Member Bowders. Any comments or a motion? Okay, Member Donahue, any comments or a motion?
I move approval.
Great. Member Medina, I'm looking for a second or comments.
Second.
For both?
Have a second.
Second. Vice Mayor Martinez?
No comment.
Okay, and I have no comments. I have a motion from Member Donahue, a second from Member Medina. Roll call vote, please.
Councilmember Bowders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats.
Aye. Okay, with that, we move on to 11.2. Ordinance of the City Council amending our planning regulations to eliminate parking requirements. And I'll go to Mr. Bryant.
Yes, I am here. Can you hear me?
I can.
All right. So, Mayor Pats and members of the City Council, you have before you consideration of the first reading of an ordinance to eliminate the minimum parking requirements by amending the planning regulations to do that. Next slide, please. Next slide, please. This is an overview of what I'll talk about tonight. First, a little bit of background, then a diagram that summarizes our current parking requirements, brief discussion about how the code would need to be amended to eliminate the parking minimums, and a second diagram that shows what the effect of that would be. And then there are a number of issues that are a part of this that I'll discuss briefly. Those include accessible parking, electric vehicle charging stations, and bicycle parking. Then there are some other miscellaneous code modifications I'll talk about briefly. Then review what the Planning Commission did at their February 27th meeting about this. And finally, I'll end with the staff recommendation. Next slide, please. So by way of background, last year in March, the Council directed that an ordinance be prepared to eliminate the minimum parking requirement. In doing the research to prepare that amendment, staff also identified a number of related parking issues that needed to be addressed. The Planning Commission held a study session on these issues on July 25th last year. And at that study session, the Commission raised a number of concerns, including the ability to require parking if it appeared to be necessary for a project. If we eliminate the parking minimum, then the city could not require any project to have parking, even if we felt it was necessary. Concerns about accessible parking, because that is, under the building code, a percentage of parking actually provided, and if no parking were provided, then no accessible parking would need to be provided. Similar concern about electric vehicle charging stations, which also are a percentage of parking to be provided. Those also would then therefore not be provided if there was no parking at all. They had concerns about short-term bicycle parking and suggested that some of that could be in lockers instead of, or in addition to racks. This is the outside parking for visitors and shoppers. They expressed a desire for shared public parking facilities like municipal garages that the public could use, as well as alternative means of transportation. And finally, they discussed the accommodations for scooters and also for transportation network companies such as Uber and Lyft. Next slide, please. The City Council then held a study session last September And at that study session, after you heard the staff presentation and considered the Planning Commission's comments, you directed that the parking minimum be eliminated, that the accessible parking should be based on the estimated parking demand, even if there was no other parking provided, that the bicycle parking requirements should be uncoupled from the auto parking requirements so that they aren't a percentage of auto parking that's actually provided anymore, but is a separate standalone requirement. Concerning the provisions for short-term bike parking, scooters, and Uber and Lyft loading, that was to be deferred to the future after we had had a chance to develop some proposals and BPAC had a chance to review those. And finally, the council opined that the planning regulations are not the right tool to use for looking at municipal parking garages and transportation alternatives, but those should be considered in the future as separate efforts. Next slide, please. So this diagram illustrates our current parking regulations. If you think of parking, the amount of parking provided for a project as a spectrum or a scale from 0 to infinity, we start with what we call the estimated parking demand, and a very typical demand is 3 spaces per 1,000 square feet. And these are all spelled out for different uses in the planning regulations. And then the parking that is allowed to be provided under the current code is a maximum of 10% above that estimated demand and a minimum of 33% below that demand. So that's what's illustrated in green on this chart. Anything in that green area from the minimum to the maximum may be provided. If the developer wants to go either above the maximum or below the minimum outside this range, then a conditional use permit is required, as shown in the yellow area. Next slide, please. So to eliminate the parking minimums, the code needs to be amended, and the sections that stipulate the minimum and maximum number of spaces and that set forth the findings for the use permit that's required to go above the minimum, below the minimum or above the maximum, would need to be modified and consolidated and renumbered. And that modification would be to eliminate the minimum parking requirement and reduce it to 0, and also eliminate findings for parking below the minimum because there would be no use permit needed for that anymore. In addition, to address the concern that was raised about not being able to require parking where it appeared to be needed, new section would allow projects that provide less than the estimated demand to be conditioned to require measures to reduce the parking demand, such as alternative modes, modified work hours, and telecommuting, and so forth. So the Planning Commission or City Council, as the case may be, when a project came before them that provided less than the estimated parking demand, would have the option of including a condition of approval requiring essentially a TDM, Transportation Demand Management Program, to try to reduce the estimated parking demand. We still would not have the ability to require parking, but we could have a condition that requires measures to try to reduce the parking demand. So that's a part of this. And then finally, the sections on the transit hub overlay zone and the accessory dwelling units that reference minimum parking would be modified to reflect the elimination of the minimum. And I would note that later on your agenda, I think it's the next item, is an ordinance to amend the provisions for ADUs, and that ordinance has the exact same code sections that this ordinance has for ADUs and for their parking requirement. So we've taken pains to make sure that both ordinances have the same proposed language for ADU parking. Next slide, please. So this diagram shows what the effect of these changes would be on the code. You still have the spectrum from 0 to infinity. You still have the estimated demand, and you still have the maximum that's 10% above the estimated demand with a conditional use permit to exceed that. However, the minimum has now been moved down to 0, so that entire area from 0 to the estimated demand is now green, so anything in that range could be provided up to the maximum. And in addition, as the text there in blue below the arrow on between the minimum and maximum indicates that the project could be conditioned to require measures to reduce the parking demand. We couldn't require parking, but we could require measures to try to reduce the parking demand. Next slide, please. So now with regard to accessible parking, this is mandated by the building code, and it is a percentage of the total amount of parking provided. This ordinance would include a new section in the planning regulations that would require new construction with an estimated demand of 26 spaces or more would have to provide accessible parking based on the estimated demand, even if no other parking were provided. So, for example, the building code requires 4 accessible parking spaces for 100 total spaces. So if the estimated demand for a project for a new building were 100 spaces, then the project would have to provide at least 4 accessible spaces, even if no other parking was provided. So you'd have a very small little parking lot that had 4 accessible parking spaces in it and no other parking. But to not unduly overburden smaller projects and the reuse of existing buildings, this ordinance requirement would not apply to existing buildings, and it would also not apply to new buildings that have an estimated demand of 25 spaces or fewer. And just for reference, that's about a 10,000 square foot building. So essentially, this provision would apply to new buildings that are over 10,000 square feet. It should be noted, however, that any project, new or existing, that voluntarily provides parking would still have to provide accessible parking based on the building code requirements. Next slide, please. Concerning electric vehicle charging stations, it was noted at the City Council study session last September that EVs are automobiles, just like gasoline automobiles, and if the basic goal of this whole exercise is to reduce the use of automobiles, it wouldn't make sense to give EV charging stations the same kind of preferential treatment that accessible parking would get. So we haven't done that. So there's no requirement to provide EV charging stations if no other parking is provided. However, in this proposed ordinance, the requirements for EV charging that is provided are significantly increased from what the current code requires. And that requirement would be based on the California Green Building Code, or CalGreen, and therefore it would automatically increase with every 3-year code cycle. As you may know, the EV charging requirement in the CalGreen code kind of ramps up every 3 years, and this would then become automatic because the planning regulations would be tied to the CalGreen code. So we wouldn't need to amend the planning regulations every 3 years. It would just automatically increase every time the CalGreen code requirements increased. And these requirements would be tied to what's called the Tier 2 voluntary measures, that's the highest CalGreen standard. And the charging stations themselves would have to be at least level 2 or better, as opposed to the slower level 1 charging stations. Now, there is a significant difference between what the CalGreen requires and what our proposed ordinance would require. The CalGreen code only requires spaces to be EV capable, which means they have to have the conduit and other things for future EV charging stations, but they don't actually require the so-called EVSA, electric vehicle supply equipment, to actually be installed. But our code amendments would require those spaces to have the EVSE equipment and for all other spaces to be EV capable. And in addition, the raceways and panels for the EV capable spaces would be required to be 50% larger than CalGreen require. This is anticipation of future kind of beefier EV equipment in the future. So for example, if the EV capable space, the CalGreen code required a 1-inch conduit, we would require a 1.5-inch conduit. So, and the CalGreen code currently requires 9 EV capable spaces for 100 total spaces. The other 91 spaces are just regular parking spaces. In the Emeryville code, those 9 spaces would actually have to be EV charging station spaces, and the other 91 spaces would have to be EV capable with 50% larger raceways and panels. Next slide, please. Concerning bicycle parking, it's currently tied to the amount of automobile parking actually provided. And obviously, if you have no auto spaces, then you would have no bicycle spaces. So this ordinance amends the code to uncouple these requirements. For non-residential uses, both the long-term bike spaces, which are the secure interior spaces, and the short-term spaces, which are the exterior bike racks, would be one space for every 10 spaces of estimated auto demand, regardless of how much auto parking is actually provided. And then for residential uses, long-term requirement would remain as it is now, one space per unit, and then the short-term requirement for residential uses would be one space for every 20 units instead of one for every 4 automobile visitor spaces as the current code requires. Also, the decision makers, Planning Commission or City Council, would be allowed to make modifications to the specifications of the bike parking design standards as appropriate, just to make sure that we can tweak them as we need to make it actually work. There's also a provision in here that for long-term bicycle parking may be substituted on a one-to-one basis for short-term spaces for non-residential uses of 3,000 square feet or less if long-term bike parking is not feasible due to lack of space. So, for example, if you have a very small, say, 2,500 square foot store, and they have a requirement for one secure bike parking space, and they just don't have any place within that 2,500 square feet to fit that one bike parking space, they could be allowed to substitute an additional bike rack outside. Next slide, please. So miscellaneous other code modifications include the elimination of mandatory code language like parking requirements and required parking to make it clear that it's no longer mandatory, the elimination or modification of certain provisions related to substitutions or credits for required parking, since parking is no longer required, modification of provisions related to existing parking to allow it to be reduced or eliminated altogether, additional modifications necessary to implement the elimination of the mandatory parking and other miscellaneous cleanup measures. Next slide, please. So the Planning Commission held a public hearing on this proposed ordinance on February 27th of this year. There were 4 commissioners present at that meeting. There was a vacancy on the commission at the time, and Commissioners Keller and Sohani had excused absences. After closing the public hearing, the commission voted 3-1 to recommend that the council adopt the proposed amendments. Commissioner Donaldson, Vice Chair Thompson, and Chair Guerrero voted yes, and Commissioner Young voted no. He expressed skepticism about the practicality of the proposal. Next slide, please. So our recommendation is that you introduce this proposed ordinance after a motion to read by title only, take public testimony regarding the ordinance, and then adopt the first reading of the proposed ordinance. And that concludes my presentation. I'd be happy to respond to any questions.
Great, thank you. Member Bowers, any clarifying questions?
No questions, Mr. Mayor. Just want to thank Charlie and the Planning Commission and staff for moving this forward. I'm just really happy that we got this to this point, and look forward to moving it today.
Great, thank you. And just a reminder to the public that I will open the public comment after we do clarifying questions. So please submit your comments now. Member Donahue, clarifying questions.
That was very clear. Thank you, Charlie.
Excellent. Member Medina, clarifying questions?
None.
Vice Mayor Martinez?
No, Mayor, thank you.
I will just say thank you again to the Planning Commission and to Mr. Bryant. And just to stall for time, before I open the public hearing at 8:39, I call the public hearing open, and just go to the City Clerk for any comments.
There are no questions on this or comments on this item.
No virtual testimony, as you've called it in my notes, which I really appreciate. And with that, I close the public hearing at 8:39 as well. And I will go to discussion, and again, I'll start with Member Bowers.
No discussion items, Mr. Mayor. Thank you.
Member Donahue.
I just want to say that while this may sound radical to some elements of the public, it's up to the property owners whether they think they don't need that parking and they provide alternatives to parking. As everything is taken into account.
Very true. Member Medina.
I'm excited for this to be implemented. I've seen it many times now. I feel it's been extremely vetted. This is a motion to read by title only.
Okay. I have Member Martinez, comments or a second?
I'll do both. I'll make a second and just say that I've been seeing a lot of posts on Twitter, and maybe I just follow a certain group of people who are apt to think this way, but, folks are noticing a lot of families and pedestrians, walking single file down the sidewalk and, next to an empty street, and just pontificating that we could have such a broader sidewalk for people to actually walk on. And, anytime that we can, encourage people to take other modes of transportation, that makes me happy. So I'm happy to support it.
Thank you for that. So I have a motion from Member Medina and a second from Vice Mayor Martinez for reading by title only. Roll call vote, please.
Councilmember Bouders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats?
Aye. And I'll go back to you, Member Medina, for a motion on the item. Oh, sorry, let's read the title.
Yes, thank you, Mayor.
Right.
An ordinance of the City Council of the City of Emeryville amending Article 4 of Chapter 4 of the Planning Regulations to eliminate the minimum parking requirements and to make other related modifications to the planning regulations with a secret determination of an environmental impact report for the general plan certified by the City Council on October 13th, 2009. Thank you.
Thank you. And with that, I'll go back to you, Member Medina, to make a motion.
So moved.
And second, Member Martinez. I have Member Donahue seconding it. Thank you. So I have a motion by Member Medina, second by Member Donahue. Roll call vote, please.
Councilmember Bouders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats?
Aye. Okay, that is brings us to 12.1.
Oh,
In ordinance of the City
11.3.
Council. I'm sorry, what? Oh, 11.3. Sorry. I scrolled down one too far. So 11.3, in ordinance of the City Council amending the planning regulations for ADUs. And I'm back to you, Mr. Bryan.
Associate Planner Diana Kina is going to make the staff presentation on this item.
Yes. Good evening, council member. Yes?
No, go right ahead.
Go right ahead? Okay.
Yes.
Here we are again talking about accessory dwelling units a year after we did it before, because the state has once again adopted some laws that limit what the city can limit. Next slide, please. Now we need to allow junior accessory dwelling units, which are a small unit that can share a bathroom with the other unit in the house, ADUs on lots with more than one existing unit, multiple ADUs, parking and setbacks, and people can request a 5-year delay in building code enforcement of ADUs except for health and safety issues. Next slide, please. We may not require owner occupancy of an ADU or the other unit that's on the lot like we used to, but we do still require junior ADUs. They're in the same building using the same bathroom. We may not require correction of non-conforming zoning conditions, which is pretty much dimensions. We may not require meeting the lot size standard for the zone, or replacement of parking when a garage or carport is converted to or replaced by an ADU. And we also may not require them to meet setbacks when they convert an existing structure like a garage or something to an ADU. Next slide, please. In terms of number of units on a lot with one single unit, they can add one ADU and one junior ADU in any of these configurations. It could be either one in the single unit structure the house, and detached from the single unit structure would be an ADU, and it could be combined with a junior ADU. Now, our staff who actually implements this has been asking about, well, what about units that are attached but not within? So we want to add that because the state doesn't really explicitly address it. So we're proposing we add that. And then on a lot with more than one existing dwelling units, in proportions of the existing structures that are not used as livable space, like storage rooms, boiler rooms, parking, stuff like that, at least one ADU or 25% as many units as exist on the site. So if you have a 100-unit apartment building, you can convert the garage to 25 units. And detach from existing structures to ADUs, which might more be used in the house lots, duplex lots. Next slide, please. Now, these statutes have three different things to say about the size of the ADU, which can be fairly boggling. The maximum size of the ADU, the default in the statute is 1,200 square feet. The attached ADU may be limited to 50% of the principal unit, which is what the existing ordinance says. Cities may set the maximum size at 850 square feet, 1,000 for 2 or more bedrooms, which is less than the maximum is now. Cities must approve 800 square feet, even if it means waiving some of the standards about dimensions and such. So the city staff thought, let's just keep it simple and just say that the ADU can't be larger than the largest existing unit on the lot. And we will waive any planning requirements that would prohibit an 800 square foot ADU. And then about the minimum size of the ADU, the health code definition of a efficiency is that it has to have 150 square foot great room plus a closet and a bathroom. So if we just say 150 square feet, it'll be a little bit more than that, but that's a nice number we can use in the ordinance. And then for maximum size of junior ADU, that's 500 square feet. Next slide, please. And short-term rental is rental for 30 days or less. Airbnb is an example of short-term rental. Emeryville currently allows short-term rental in detached dwelling units, even if there are more than one to a lot, in the entire unit for up to 90 days a year, or in part of any unit any time when the occupant's present with a permit. The state now requires ADUs that are permitted under that 800 square foot rule to be rented for 30 days or more. And we are not going to be able to keep track of which ones those are. So staff is proposing that we prohibit short-term rental in all ADUs. Next slide, please. The statutes also address common interest developments. And they say that homeowners associations, CC&Rs, may not prohibit or unreasonably restrict ADUs and junior ADUs. Now, cities don't regulate those, so they're not in the proposed ordinance, but we want to let everybody know about that. Next slide, please. One of the new laws is that the city may allow separate sale of ADUs that are developed by nonprofits as affordable units with a 45-year affordability restriction, and that the next housing element must include some sort of plan to incentivize and promote affordable ADUs. Next slide, please. So when we went to the Housing Committee, my first thought was, oh yeah, that's a way to meet the housing element requirement. But the Housing Committee wisely said, well, no, that's not a very efficient way to develop affordable housing. Now, in Emeryville, it would not make sense for an affordable housing developer to buy a lot and build an ADU on it. So they do not want to have that provision to allow that. And I think that makes sense. Other things we have a choice about are applying the state rules for number of detached units to attached units, just to fill in that gap in applicability. And when I went to the Housing Committee, we were saying let's allow ADUs up to 1,200 square feet, but later we realized that we could just say, let's just say it can't be any bigger than the existing house, which I'm sure the committee would agree with because they were into more housing. and we still have to waive the standard to allow an 800 square foot ADU. And they agreed that we should prohibit short-term rental in all ADUs to avoid the confusion of prohibiting it in only some of them. Next slide, please. Now, to amend the planning regulations, the council has to make some findings. The first one is that it's consistent with the general plan, and it is because it helps to implement housing goals, especially about the mix of housing types. The second finding is that it's necessary for public health, safety, and welfare, or will benefit the public. It does this two ways. It expedites the development of housing where infrastructure exists, and housing units are needed to mitigate the housing crisis. Next slide, please. The third finding is that the proposed amendment has been reviewed in compliance with the California Environmental Quality Act, CEQA, and this year there is a new provision in the Public Resources Code that just says flat out CEQA does not apply to ADU ordinances, so we can use that. And the fourth finding is for changes to zoning maps, but we aren't doing that, so we don't have to do anything about that. Next slide, please. So here's what the Planning Commission recommended. Let's not allow separate sale of affordable ADUs. Let's allow ADUs up to the size of the principal units. Let's prohibit short-term rental in all ADUs, and let's apply the state rules for the number of detached units to the attached units. Everything else in the proposed ordinance is what the state said. It's not stuff we had much choice about. Next slide, please. So, staff recommends that the council consider adoption of the proposed amendments to the planning regulations and the building regulations as detailed in the resolution. And that completes my presentation, and I'll be happy to answer any questions.
Great. Thank you for that. And so we're going to clarifying questions. Member Bowers, any clarifying questions?
No questions, Mr. Mayor.
Member Donahue, any clarifying questions?
No questions.
Member Medina, any clarifying questions?
I do have one, actually. What is currently the process and wait time to get a permit to build an ADU? Do we have over-the-counter permits available?
They're just about over the counter. They're zoning compliance review. So there's a set of things they have to meet. They basically have to meet the building code. But in terms of planning, if they meet the basics, we just have to say yes. We have been telling them about things they will have to think about, like meeting the building and fire code, so they don't think, oh, we're all approved, we can just do it. But our approval is just zoning compliance, which is very minimal.
Okay, thank you.
Vice Mayor Martinez?
No questions.
Great. So at this time, it is 8:53. I will open the public hearing and take virtual testimony.
All right, Mayor Pats, I do have 2 comments that I've received so far. This first one, and I apologize in advance if I'm mispronouncing people's names. This first one is from Kiran Shenoy. I wish to comment about item 11.3. My comment is, the Bridge Association of Realtors believes that the draft ordinance conflicts with state law in a number of ways. We would like the following points read into the record. 1. The draft ordinance limits ADUs to the size of the main dwelling. Instead, it must allow ADUs to be up to 850 square feet for 1 bedroom or 1,000 square feet for 2 bedroom, and then it cites the government code. Number 2, the draft ordinance limits ADUs to the bedroom count of the main dwelling. California HCD is advising cities that they may not impose any bedroom count limits on ADUs. Number 3, the draft ordinance prohibits ADUs where there is any non-residential principal use of the lot. Instead, the city must allow normal ADUs on any lot zoned to allow single-family or multifamily dwelling residential use if the lot includes a proposed or existing dwelling. And then it cites a government code. For the special ministerial categories of ADUs, including ADUs in multifamily buildings, those ADUs are expressly allowed in any residential or mixed-use zone. And number 4, the draft ordinance allows ADUs approvals to be appealed to the Planning Commission. This is not allowed because the city is not allowed to ever hold a hearing on an ADU application. The legislature intended this provision to prevent any opportunity for neighbor appeals. Of course, if an ADU application is denied, the applicant has the right to voluntarily appeal the decision. And now I will go on to the second comment from Alla Agafanov. The change for detached ADU setbacks requirements from 3 feet at sides and 5 feet at rear to 4 feet at both side and rear setback lines would not allow nearly as much usable living area. The side setback for primary residences is only 3 feet, and making ADU side setback requirements more restrictive would impact feasibility of new detached ADUs by effectively reducing the buildable width by an additional 2 feet. And I'll see if any more have come in since I started reading, and I see no other comments.
Okay, it is 8:56. I will close the public hearing and go to Member Bowers for discussion.
Thank you, Mr. Mayor. I would like to offer both Charlie and the city attorney an opportunity to respond to the comments from the first public comment, please.
Charlie, why don't you go first?
Well, unfortunately, I don't have those comments in writing in front of me, and I was just trying to listen to what the city clerk was reading. I think that some of the things that the commenter said were inaccurate, but I'm a little hard pressed to say which are inaccurate and what our code amendment says. I might ask Diana, who is closer to all of this than I am, if she has any thoughts on those comments.
850. Excuse me?
Go ahead, Diana.
Okay.
Go ahead.
The first comment is about, we said it can't be bigger than the existing unit, and she's invoking the numbers that are in the state law, but we think that it's not an accessory unit if it's bigger than the existing unit. The bedroom count, the state doesn't prohibit that. It doesn't specifically allow it, but it doesn't prohibit that. I think the other one is about existing versus proposed. We tried to keep any language about the unit's relationship to the house as including a proposed house, but maybe we missed it somewhere. And it definitely, I don't know where she read that it can be appealed to the Planning Commission.
Also about the setbacks, it's true that our existing side yard setbacks are 3 feet in residential zones. I thought we had the same provision for ADUs. I don't believe we introduced a 4-foot setback for ADUs, did we, Diana?
We might have inadvertently done that, in which case we want to change it.
Oh, all right.
Mayor, may I? This is Michael.
Yes, please.
Echoing Charlie's comments, I don't have the benefit of seeing what the code sections are that are relied on by the commenter, and so unfortunately I can't provide advice on what the comments are that are given. Certainly, if the council wishes to put this over to allow staff for time to review this, that's also an opportunity. That's also an option, I think, in front of you as well.
Mr. Mayor.
Thank you. Member Bowers, back to you.
Thank you. In follow-up to the answers to those questions, I would like to, waiting to hear still from the rest of my colleagues, of course, Mr. Mayor, I would like to ask Sherry, if in the public comment you said citing a government code section, can you actually state what government code section was cited by the speaker? Because then I'm going to make a suggestion.
Yeah.
Okay.
I did see the 4-foot setback in there, by the way. Go ahead, Sherry.
Yes.
Okay, and there are several, so bear with me. Let's see. Okay, under their comment of number 1, they cite Government Code 65852.2 C2B.
Mm-hmm.
Is that the only citation?
No, I'm scanning through here. There are others. Okay, under their point number 3, they cite 65852.2 A1D, and then Roman numeral 2. I'm sorry, I don't know how to read these out correctly.
We recognize them. We've studied them so long.
And then there's another one at the end of that same point 3, 65852.2 E, and then letter I, it looks like. And in their 4th point, they have 65852.2 A3. And I believe I got them all there. And yeah.
Mr. Mayor, I'd like to suggest that we have several items that will require additional discussion this evening, and for the benefit of staff, just to see if these could be corrected, the 3 and 4 foot thing, if these are small mistakes, and then also the issue about whether or not the square footage of the structure can exceed can be fixed or can be over a certain amount. I would like to just ask that if Sherry could either transmit a photo of that comment just so that Michael and Charlie and Diana have it. I would like to make a motion to table this until the end of the meeting, and if there are answers at the end of the meeting, we could pick this item back up, and if not, we could continue it to an additional time if that's okay with staff.
I support that. Member Donahue, what are your feelings?
I agree. Let's try that.
Okay. Member Medina?
Sure.
And Vice Mayor Martinez?
Yes, that's fine.
So I'll make a motion to table.
I'm sorry. Yeah, so go ahead and motion to table.
Yeah, motion
Okay.
to table until the end of the meeting.
And Mayor Pats, I have forwarded that message. I was able to forward it to Charlie, Diana, and the city attorney in the meantime.
Can you forward it to the council as well so we can be looking at it?
Okay,
Is this by email?
yes, check your email.
Okay.
Great. And so I have a motion from Member Bowders and a second from myself. Roll call vote, please.
1 sec.
Oh, sorry.
Okay, Councilmember Bowders.
Aye.
Councilmember Donahue.
Aye.
Councilmember Medina.
Aye.
Vice Mayor Martinez.
Aye, and Andrea's asking for the comment too, by the way.
Okay, and Mayor Pats.
Aye. Okay. With that brings us to action items. We're on item 12.1. And so that's I'm sorry? Mr. Gina, are you
Thank
to present on this?
Thank you. Assistant City Attorney Andrea Viseshwara is going to be presenting on this one. Thank you.
Okay.
Good evening, Mayor Pats and council members. Can you hear me? This is Andrea.
We can. Thank you.
Okay. Are we ready?
We are.
Okay. So tonight I have a brief presentation for you on the rental repayment ordinance, and this is related to the city's response to the COVID-19 pandemic. Next slide, please, Sherry. On March 19th, the City Council adopted 2 ordinances. One was an urgency ordinance, number 2, and the other was the first reading of a regular ordinance, ordinance number 3, both of which impose a moratorium on residential rental evictions for failure to pay rent. As I've learned this evening, there will be more to that story, but for now, that's what you need to know for this item. At the same meeting, after the City Council had acted on those ordinances, the City Council directed the City Attorney's Office to return with an ordinance that would require landlords to offer a repayment plan over a 12-month period after the COVID-19 emergency came to an end, for tenants to repay rent that was owed during the emergency that was not paid. Next slide, please. And the council's concern was that once the shelter-in-place order was lifted, that tenants would still need time to increase their household income in order to pay back the rent that was owed during the emergency. And therefore, they wanted a regulatory scheme that would allow for that to happen. And so, stability in housing would be necessary not only in order to help with the pandemic, but also for the economic recovery. Next slide, please. And so the proposed ordinance. Under the proposed ordinance, prior to evicting a tenant from a covered unit for failure to pay rent, the landlord must show that that prior to delivering the 3-day notice, the landlord has offered an affected residential tenant a reasonable repayment plan to repay the rent owed but not paid over a 12-month period beginning from when the COVID-19 emergency concluded. And so over the next couple of slides, I'll get into what is an affected residential tenant and what a covered unit is. Next slide, please. An affected residential tenant means a tenant or tenant household who, as a result of the COVID-19 pandemic or declaration of the Alameda County Public Health Officer or other local, state, or federal authority, has been instructed to shelter in place in their home. Currently, this is pretty much everybody in Emeryville. Next slide, please. And so it's important to note that the ordinance being proposed amends Chapter 40. And in Chapter 40, we have certain types of shelter that is excluded from the regulations of Chapter 40. And so a covered unit excludes hotels, motels, lodging houses, residential homes if the stay is for less than 30 days. It also excludes single owner occupied residence when the owner rents 2 or fewer rooms, dwelling units in a nonprofit cooperative, dwelling units where rent is regulated by a governmental authority if application of Chapter 40 is preempted by either federal or state law, housing accommodations in certain facilities licensed by the state, so for example, residential facilities, and housing units owned by another governmental entity. Next slide, please. And as I said before, the proposed ordinance amends Chapter 40 of Title V of the Emeryville Municipal Code, which is a section that regulates landlord-tenant relations. And there are 2 main reasons for why staff is proposing to tie it into Chapter 40. The first is we have an existing program for governing landlord-tenant relations, and so we can tie this repayment plan regulation into that ordinance. Second is that under Chapter 40, the city manager has the authority to issue implementing regulations. We can imagine that there's going to be a lot of questions about how implementing a repayment plan will work, and staff such as city attorney's office and EDH, we've already started thinking about how this might work and what we may need to do to regulate it. One of the things that we're doing is looking at what other cities are doing and trying to come up with the detailed plan that's necessary to govern a rental repayment plan. And so by tying it into Chapter 40, the city manager will have the authority to issue those regulations that really get into the weeds on how this will work. Next slide, please. On April 1st, 2020, staff provided a summary of the proposed ordinance to the Housing Committee, and the Housing Committee voted unanimously to recommend approval of the proposed ordinance, with the exception that lodging houses should also have to offer a reasonable 12-month repayment plan as well. Next slide. And that is it. And I'm available for questions. I also have Chad Smalley is on the line and Valerie as well from EDH to assist in any questions.
Thank you for that. Once again, I'll remind the public now is the time to submit your comments for this item as I go through the City Council clarifying questions. Member Bowders, clarifying questions?
No questions, Mr. Mayor.
Member Donahue.
What define a lodging residence?
There is no definition in the code for lodging residence. I believe that there is one building in Emeryville that would qualify as a lodging. I think Valerie may be able to speak more to that property. Or not.
No, I'm here. I'm sorry. Yes.
Okay.
This is Valerie from EH. So yes, as far as I'm aware, there is only one property within the confines of Emeryville that would qualify as a lodging residence. And so at the Housing Committee meeting, the Housing Committee was concerned about that property and did recommend those tenants potentially could be vulnerable and should be included as a covered unit within the proposed ordinance.
Thank you. Member Donahue, does that answer all your questions?
Well, then, if we did include them, is that falling out of the code area of the Chapter 40, or what you were saying was a way to regulate? Could we add this lodging residence to that from a technical viewpoint, Andrea?
Yes, if the council would like to continue to exclude lodging houses as a covered unit under Chapter 40, but require them to offer a 12-month repayment plan, yes, the council can do that, and we can come up with proposed language that would facilitate that decision by the council.
Okay, thank you. Thank you, Member Donahue. Member Medina.
I have no questions.
Vice Mayor Martinez.
So, Andrea, would we be able to reconsider the inclusion of lodging houses in Chapter 40 altogether and include it in the new ordinance?
Yes, you could reconsider whether you want to include lodging houses in Chapter 40. Whether you would do that on the fly tonight would be something I would defer to the city attorney on, given that the way the title of the ordinance was phrased and the way it was noticed in the agenda, it may not cover that.
So, Mayor, this is Michael. So I would recommend against amending Chapter 40 to deal with lodging houses generally tonight, and I would recommend that if the council wishes to do that, that should be taken up in a future as a future scheduling item or a future agenda.
Okay, thank you. Vice Mayor Martinez, did I answer all your questions?
Yes, thank you.
Okay, and with that, I will look to Sherry for public comment.
There are no comments on this item.
Okay. Member Bowders, sorry that you started the alphabet, but you get to go first on these items. So.
Thank you, Mr. Mayor. I'd like to just ask if staff could present my red line draft for this item.
Would it be, Councilmember Bowders, can you see what I'm pointing to?
Yes, it should be that one, yes. Oh, could you use the Word document, though, because the red line doesn't show up? Thank you.
Is that it?
That's correct. Thank you.
Sorry.
No worries.
All right.
Member Bowders, you still have the floor.
Thank you, Mr. Mayor. I want to also, again, thank the City Attorney's Office. They have spent a lot of time with me. I'd like to address all the questions that were raised by my colleagues in this proposal. So what's before you is an alternative to one section of the proposed ordinance for tonight related to landlord repayment. To provide some clarification, the language here is clarified. There was some concern I had about the sentence beginning with the word "in addition" and making it appear as if the first sentence that was from the existing tenant protection ordinance had to be had to conjoin with the subsequent sentences. And so this language was sent to the city attorney, and he's had the opportunity to review it and consult with me on it, and he's not saying he's approving of it, but he agreed that I could present this evening as such. And so basically to alter it to say that this would apply to affected residential tenant as defined in our code section, and that rather than specify that it be a 3-day notice, that we simply say a notice of termination for non-payment, because some public housing programs require a 5 or 10-day notice for notice of termination, or a 7-day notice. And so we're simply covering all notices of termination for non-payment of rent. And then we're requiring that there be an offer to from the landlord to the tenant for a repayment of the total sum that's unpaid, occurring between April 1st and the expiration of the governor's order, and that the repayment plan must be presented in writing and may not be for less than a 12-month period from the expiration of the governor's order. My request of my colleagues is to approve this language as more precisely capturing the people we're trying to protect, and with it to give staff guidance tonight for several things. The first is to ask them to come back with or to produce alongside this regulations that will address late fees, that will address the amount and periodicity of payments. In other words, in a 12-month repayment plan, we don't want a landlord to offer a program without further detail that says you can pay $1,989 in month 1 and $1 a month in the following 11 months. So we need some regulation that clarifies the obligation of the landlord's repayment plan. So the periodicity, the amount, we'd like to make sure that there are no late fees, and we'd like to cap interest at what's statutorily allowed without depriving the landlord of the right to receive interest on an investment. So those would be those pieces. And then subsequent, I was at the housing committee meeting, and there was a discussion about lodging houses. As a personal anecdote, my first place I lived after being unhoused was in a lodging house. And there are few people I can think of who make it in a crisis like this that are more vulnerable than people in lodging houses. And I'm very grateful to the housing committee, and I would recommend that we ask for an immediate action item, which I will be doing at future agenda items tonight, an action item to visit Chapter 40 for the express limited purpose of visiting the definition of a excluded dwelling, so the exclusions list in the definitions, so that we have the opportunity to simply remove lodging houses, which would entitle them to all of the protections of our tenant protection ordinance, all of our just cause eviction ordinance protections, as well as all the relief that's being cited here, because I agree with the city attorney for housing this under Chapter 40 of our code here. So that would be the recommendation I would suggest with this language, is a motion giving direction to do those things. Thank you, Mr. Mayor, for the floor.
You're welcome. I have just one question, and it's going to seem redundant for the evening. Why are we doing it exactly when the expiration of the emergency order as opposed to 30 days after? It seems to me that it's pretty standard, just in practice, that we give 30 days after something before we give in. Based on how people earn money, paychecks don't come immediately after the lifting of the stay-at-home order. So I'm going to make that as a friendly amendment to all of this as well, but I just wanted to ask you, while you were discussing it, why we didn't look at the 30-day.
Thank you, Mr. Mayor. And I would, on this one, I would defer to the city attorney insofar as, unlike the health and safety issue of protecting the health, safety, and welfare of a resident, which the police powers, I believe, allow us to do that at any time as long as they're reasonable under case law. This is a repayment plan, and it's not necessarily directly correlated to health, safety, and welfare. So arguably, if we were to simply continue tolling rent after the expiration of a crisis, we'd have to just simply make an argument on the record as to why we were doing that. I'm not opposed to it. It would just potentially subject this statute to a legal challenge, which could jeopardize everybody if the repayment plans were all found to be invalid. So I think it's much more clear that it goes till the end of a state of emergency, and based on the way this is written, you can't give somebody a notice until you've offered this plan. So no matter what, anybody starting the day after the crisis would at least have the opportunity to negotiate repayment of anything that happened during the crisis. I agree with you, it won't solve the person's fiscal problem the next day they're not miraculously employed, but it's kind of trying to balance that tightrope. So if you feel strongly about extending it, we could. I just am a little more concerned about the legal ground for continuing a repayment plan farther out after a crisis ends.
Thank you. I just that was you answered that quite well. And just to clarify, starting the payments 30 days after the crisis ends, as opposed to the plan. You obviously negotiate the plan right away, but it's that in time. I think you addressed that. So, I'd like to give the city attorney a chance to weigh in on my question, and I'll go to you, Member Donahue.
Andrea, did you want to respond to the mayor's question?
So your concern is that basically the payment not begin within, in other words, payment right after the emergency ends.
Correct. Just to give a 30-day period for the installments to begin.
So, Mr. Mayor, this is Christine. If I could just jump in on this to point out that
Please.
this is related to the next item in terms of the renter assistance program, which is structured to begin at the termination of, to begin when this ends, so that the renter assistance would be available beginning when the eviction moratorium essentially expires and the repayment plan is to be offered. So I don't know if that helps.
It does. Again, I just want to make sure we're not setting people up to fail. So I'll go ahead, Andrea.
I apologize, Mayor. So when I'm looking at the language, it doesn't really talk to the timing of when the repayment plan begins, and I think that is something that is one of those details we'd work into the regulations about this whole process of when does the landlord have to offer the repayment plan? 24 hours notice sufficient? Probably not. And so getting to when it's offered, when it has to be accepted. And so I think that might go to when the repayment plan begins, that while you may execute it, let's say, on day one after the emergency ends, your payment may not be owed for another 30 days.
Right. And to me, the 30 days just moves that 12 months out. But I'm going to leave it there. And give Member Donahue a chance to speak. Member Donahue?
I don't have anything to say.
Okay. Member Medina?
No question.
I think we're past questions and this is discussion. So, Member Vice Mayor Martinez?
No comments.
No comments. Okay, with that, I will entertain a motion. I'm going to go to you first, Member Bowders.
Thank you, Mr. Mayor. I'd like to make a motion to approve the ordinance as drafted. Actually, do you need a motion by title only first, or?
Motion by title only first, please.
Okay, I'll make a motion to read this by title only.
And I'll second that. Roll call, please.
Councilmember Bouders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez? And Mayor Pats?
Aye.
An ordinance of the City Council of the City of Emeryville amending Chapter 40 of Title 5 of the Emeryville Municipal Code, Residential Landlord and Tenant Relations, to provide a repayment plan for rents in arrears to residential tenants impacted by COVID-19 emergency with a CEQA determination of exempt pursuant to California Resources Code Section 21080 sub B4 and State CEQA Guidelines 15269 sub C and 15061 sub B3.
Okay, thank you. Member Bouders, a motion for the item?
Thank you, Mr. Mayor. I'd like to make a motion to approve this ordinance as amended in the red line presented on the screen at this time, and to accompany that direction to staff as it relates to regulations to ensure that there are regulations prohibiting late fees, regulating the periodicity and amount of repayment per month, to cap to cap interest on any amounts owed by a tenant, to outline clear timing to afford a tenant an opportunity to respond to a repayment offer, and to the mayor's comment, to determine the most appropriate time for the onset of payments to begin subsequent to the expiration of the governor's state of emergency. That will be my motion.
Thank you for that, and I will go ahead and second so we can move to a roll call vote.
Councilmember Bouders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats?
Aye. Okay, with that, we move on to item 12.2, the resolution of the City of Emeryville authorizing the city manager to enter into a personal services contract. City manager.
Mr. Mayor, I believe Chad and Valerie have the presentation on this one.
Great.
Okay. Good evening, Mayor Pats and City Council Member Valerie Bernardo, who's on behalf of Economic Development and Housing. And I'm here to discuss the Emergency Rental Assistance Program. On March 19th, it was requested that the staff come back with a proposal related to implementing an emergency rental assistance program. And so today I'm going to give you guys an overview of some of the policy guidelines that we've drafted related to that program, as well as provide you with a couple of policy decisions for you to review. Something? The goal of the Emergency Rental Assistance Program is really to do two things. One, it's to address potential homelessness, but also to address potential displacement of tenants that have experienced a loss of income due to COVID-19. The program that we have outlined for you guys today, as the city manager mentioned, is intended to assist eligible tenants with paying rent that coincides with the expiration of the eviction moratorium ordinance, which is currently scheduled to end on May 31st, 2020. We've developed the program to start the day after that ends because we feel like that is when residents will be most at risk for eviction, since the day after that, they will need to start paying rent. We view this program as a third prong to the city's efforts to address tenant relief assistance, the first being the eviction moratorium that the council adopted, the second being the repayment plan ordinance that was proposed this evening, and then again, this being the third prong, the emergency rental assistance.
I'm sorry, I can't hear you.
Is that better?
Yes.
That's much better.
Okay. Next slide. Okay. So what we've tried to do is we have done some outreach to 3 local nonprofits, trying to identify an entity that could assist and has the capacity to implement the program. We have reached a nonprofit that has administered a similar program, and that nonprofit that we have that we are recommending is BATS, which is the Bay Area Community Service Agency. We currently administer a similar program within the city limits of Oakland called Keep Oakland Housed. Their role would be to accept applications, review applications, and verify information. They would be issuing payments and they would also be responsible for direct communication with the tenants and landlords on the application status as well as payment status. They would also assist in working with local city staff on collecting applicant participant data related to evaluating the effectiveness of the program. Next slide. Some of the details of what we've outlined for applicant eligibility include that you must be a resident of the city of Emeryville. There must be a current lease agreement. They must be current on the rent that is due prior to March 19th, 2020, being the effective date that the eviction moratorium went into effect. The household income of those that are eligible must be at 100% of AMI or below as of March 4th, 2020. And the March 4, 2020 deadline was created because that was the date that the state, that the governor actually issued the emergency order within the state of California. They must identify a documented loss in household income due to COVID-19 pandemic, and they must do a self-certification of their inability to pay the next month's rent. Those eligible households at 100% of AMI are outlined in the chart below. We've identified between a 1 and a 4-person household, and of course those numbers would increase depending upon the size of the number of people in the unit. Next slide. There would be some ineligible tenants or landlords that would not be able to participate in the program. The first one would be those that are Section 8 tenants, and the reason they're identified as an exclusion is because their rent is typically based off of their household income. So as their income decreases, they actually would have an eligibility through their service provider to receive a reduction in their rental obligation. Second, be any tenant that has received assistance under another rental assistance program since March 4th, 2020. Tenants that are immediate relatives of the owner of the unit in which they are renting would also be excluded from applying for the program, as well as single owner-occupied residences that have 2 or fewer tenants and the landlord does not have a valid residential landlord business license. Those are the four cases in which we've identified that people would not be eligible to apply for the program. Next slide. The payment standard would be based off of the lesser of the tenant's actual rent or the maximum affordable rent for the unit size based on need. We tried to tie this standard to the existing affordable housing standard that is actually issued on an annual basis and approved by City Council. On an annual basis, we do present an affordable housing table that identifies the affordable income levels, sales prices, and rent limits on a variety of income levels. What we've identified here is what those rent levels would be at 100% of AMI based off of the size of the unit. If somebody's rental rate would exceed the maximum affordable rent as identified, the tenant would be required to remit the difference to the landlord prior to the city dispersing the funds. Next slide. The funding process would require that funds are distributed directly to the landlord unless alternative arrangements authorizing payments to be released to the tenant are approved by the city. We've included that additional authority just to allow in a specific case where a landlord did not want to provide the required information or did not want to participate in the program, that the tenant would still have the ability to participate because we could issue the payment directly to them, and then they would be responsible for remitting the payment directly to the landlord. Funds would be issued in the form of a grant, and the city has estimated, based off of the information provided, that we would be able to issue approximately 150 rental payments at an average payment of $2,374. Next slide, please. We do feel like it's important that anytime we implement a new program that we determine whether or not it's effective. So we have identified several tools that we would want to use to evaluate the effectiveness of the program. The first would be the collection of the applicant and participants' eligibility to determine the number and percentage of households at each income level between 0 and 100% of AMI. We also would want to collect data related to those who apply and those who are actually able to participate in the reason that they experienced a financial loss. We'd want to survey the program participants to determine their satisfaction with the program and program provider. And then we would also want to do a review of eviction filings that occurred within 3 months of the eviction moratorium and the rate of evictions from program participants to see whether or not we were actually able to delay or stop eviction proceedings for those tenants. What? As I mentioned before, we do have a couple of policy decisions. One of the things that we do estimate is that with a $400,000 allocation, we probably are only going to be able to serve approximately 2% of the population in Emeryville. We do anticipate that the program will probably be very overprescribed. And so one of the things that we wanted to get assistance from the City Council on is in regards to prioritization. So related to option number one would be implementing a system where funding is made available on a first-come, first-served basis to those affected tenants that are deemed eligible. There would be no prioritization on those that are most vulnerable. Just whoever submits their application first would be eligible, and that meets the requirements, would be able to receive the funding. The second option that we have under prioritization relates to developing a system where the affected tenants' applications are ranked based on their income level. The affected tenant's application with the lowest income level would receive priority in participating in the program over other eligible tenants. So that we're really serving those who have the greatest need. Next slide. Second policy decision we have is in regards to the number of allocations. $400,000, as I mentioned before, is a lot of money, but it will go very quickly. So the first option that we have provided is that we would release all of the available funds at once, which would result in serving more affected tenants. However, all of the funding is estimated to be committed in month one, and based on some previous information we received, probably all in day one, which would leave no opportunity for tenants to apply in month two if there was still a need for existing rental assistance. This option could serve the most affected tenants, would only provide housing stability for those that need it in month one. The second option that we provided would divide the program funding, that half of the money would be released in the first month and the remaining half would be released in the following month. This would allow affected tenants who were selected to participate in month one an opportunity to reapply for assistance in month two, thereby providing a longer opportunity for program participants to become financially secure without the fear of being evicted. There would be no guarantee that those affected tenants awarded funding in month one receive funding in month two, as they would have to apply again and re-enter the application pool. This option could potentially provide assistance covering housing stability for affected tenants over a 2-month period. However, potentially we also could serve less people. Next slide. The fiscal impact to the city would be the $400,000 that was allocated through the disaster fund. We have also received information from East Bay Community Energy that they're willing to donate $31,500 to the city for COVID-19 relief efforts, and they have agreed that this would be a program that they would support. We're estimating that the cost of administering this program would be 13% of the total program fund, and we are also including in the resolution an authorization that the city manager accept the additional donated funds for the program management. Next slide, please. I did want to mention that we did bring this proposal before the Housing Committee on April 1st. They were in support of recommending approval of this program, and they did also ask that we did look out for research opportunities for additional funding to support the program, as they felt that the money would go extremely fast. So what we have before you here is a recommendation to adopt the attached resolution, which would authorize the city manager to execute a professional service agreement related to the COVID-19 Emergency Rental Assistance Program, to appropriate the $400,000 from the disaster fund from fiscal year 2019-20 from the operating budget, and to direct EDCE's donation of $31,500 to the program provider. Next slide, please. And that is the end of my presentation, and I will be available to answer any additional questions that anybody may have.
Okay, great. I will go to clarifying questions first and encourage people watching at home to submit their comments now. And just so people have it in their minds, my thought on this is after clarifying questions and public comment, we'll have a brief general discussion on this issue. And then I think what we would do is the two policy questions they asked, I will take them in reverse order. We'll do policy question 2, because I think that would inform our decision on 1. If people disagree with me, we can talk about that in the general discussion. And with that, I'll go to you, Member Bowders, for any clarifying questions.
Thank you, Mr. Mayor. Just one quick question, which is about the W-9s. And if we have a landlord who is not willing to provide a W-9, you said that there would be other process to help still fund a tenant. In the interest of preventing fraud, how are we safeguarding against a person claiming that they have a landlord who will not provide the documentation you need to see that they'll accept the funds from giving rent to the tenant? Are we still making the check out, and we're hoping that they will, we're trusting that it won't be able to be deposited by anyone else? My concern would be that they say my landlord is, ABC LLC, and that ABC LLC belongs to someone in the household or something like that, right? And so we don't have any proof or verification. So but I also don't want to deprive a tenant who has legitimate claim from getting assistance. So how is staff envisioning that would work? That's my only question.
No, that's a great question, and we did talk about that with the city attorney's office. So what we would do is that we would require the tenant to enter into an agreement with the city related to the funds. And as a clause of that agreement, a failure to provide additional information would cause that agreement to go into default. One of the requirements they would have would be to provide verification of payment of that rent within a specific number of days. If they fail to do that, then we would actually go into default. The other point I wanted to mention is that as a part of the verification process, the program provider would also be reaching out directly to the landlord to, one, verify that they're a tenant, but also to collect that information. So there will be direct communication with the landlord and the tenant. And if the landlord chose not to provide the W-9 or to participate, then we could work out that additional arrangement directly with the tenant.
Thank you.
Okay. I believe that was your only question, so I'm going to go to Member Donahue.
Yes. What about gig economy workers, say like Uber or Lyft drivers? They're not really going to be able to generate employment records in the way that many other workers can. Would they be covered by this, or would they wouldn't be considered loss of income because you couldn't verify it through an employer?
That's another great question. And so there's a variety of ways that someone could provide verification of a loss of income. That could be through their employer. It could be through a review of pay stubs. We could take a letter from the employer, but it also could be through the review of their bank statement showing the deposits that had been made. And so we've outlined a variety of different ways that somebody could provide verification back to the program provider to identify their loss of income.
Okay, thank you.
Okay. Member Medina.
Thank you, Scott. That is related to my question very closely. I was curious if you consider whether or not an applicant has applied for or received employment, in particular because if you max out the state and the new federal benefit, unemployment can be up to, I think, $4,200 a month. And so somebody who was eligible, let's say had a regular employment and got that, is going to be in a much better financial position than an independent contractor for whom the guidance has still not been released on how to file for unemployment. I'm wondering if there is a method of consideration there.
I will say I don't think that had been thought of, but I think that we can definitely look in. We will coordinate with the program provider to try to identify the best way to address this kind of changing environment where unemployment, how people apply for unemployment and when they receive it is different. But that had not been contemplated.
Okay, yeah, I think that enhanced federal benefit is very new because $450 a week in California as the max benefit was not much currently. My secondary question is, are we only covering the full amount of rent, or are applicants able to request, like, I just need $200 extra to make rent this month?
So what they would be eligible for would be the maximum based off of the unit size. So somebody in a studio would be eligible for one amount, but somebody in a 2-bedroom would be eligible for a different amount. If they needed less than whatever that amount was, they could ask for it. But the way that it's currently written is that they would submit their request based on need up to the amount that is identified in the chart. If their rent just so happened to exceed that amount, we would only pay that maximum amount, and they would then still be responsible for that difference if it exceeded what's in the chart.
Okay.
So it is a group 2.
Okay. Any other? Did that answer it for you, Member Medina? And do you have any other questions?
No, that's clear. Thank you.
Okay. Vice Mayor Martinez?
My question was answered. It was Councilmember Medina's first question, just wondering about folks who are qualified for other programs. Thank you.
Yeah, as we go through those policy things, I think that those questions will become clear. Yours as well, Member Donahue. And with that, I will go to public comment. Sherry, do we have public comment on this?
Yes, Mayor Pats, I do have one comment. This comment is from Shaylin Wells. I wish to comment about the rental eviction ordinance. I am a tenant attorney at the East Bay Community Law Center with, oh, I beg your pardon. That is not the right one. Stop that. I have a few different ones from her, so. Shoot. Okay, sorry, here we go. I am a tenant attorney in Berkeley, and my organization administers multiple rental assistance programs, including assistance programs for the cities of Berkeley and Oakland. These programs are critical to keeping folks housed. I ask that the program guidelines be amended and that this resolution be passed. The program should include Section 8 tenancies. The rental assistance program already requires that applicants demonstrate that their inability to pay rent is due to a COVID-19 related hardship. It doesn't make sense to categorically exclude Section 8 tenants, one of the most vulnerable populations, from this program if they can prove that their inability to pay rent was related to COVID-19. Section 8 tenants do not just stand to lose their homes, they stand to lose their irreplaceable voucher. Given that Section 8 tenants tend to have lower rental payments than the general population, their payments will not be a substantial drain on the overall pool of rental assistance. As written, a Section 8 tenant who remains employed but who has incurred medical bills for a child impacted by COVID-19 will not be eligible for this program because their rent is calculated based on their monthly income. The program also should include individuals who are not current on all rent due to prior to March 19, 2020. This would exclude tenants who have small rolling balances, possibly from years ago, from receiving assistance now. The program should either not require provision of a W-9, or it should mandate that landlords cooperate by providing the W-9 and accepting the rent provided by the rental assistance program, such that if the landlord does not cooperate, they cannot proceed with an eviction lawsuit. The program should not force tenants to bear the difference between actual rent and maximum affordable rent. I appreciate your work in setting this up. Please amend the program guidelines and pass this resolution. Thank you.
Thank you. That was the only comments?
Let me just double check. Yes, that was the only comment.
Okay. My screen, for some reason I messaged you, I have lost the desktop share. So if you could look at that while I go to Member Bowers for his comment.
Okay.
Thank you, Mr. Mayor. I really want to thank, again, the City Attorney's Office, who has done so much work this week. I also really want to thank the City Manager and Valerie and the Housing Committee for all the time that has been put into this on such short notice. And I really also want to thank the Council. When I outlined a memo on this one-pager at the last meeting, and you all got behind it. It's amazing how quickly we have come to a place of action. And I had the opportunity to speak to both the public commenter on this item as well as some other advocates in the last 24 hours about ways to address some of the concerns they have as outlined in the program. And for discussion, I know, Mr. Mayor, you have the 2 items you want us to discuss, and I'd just like to ask if we could see if there's support for the following minor changes as well when you bring it to discussion. The first is on the item of Section 8 tenants. I agree that Section 8 tenants are the most vulnerable. When they were originally proposed to be excluded from receiving assistance, it's because Section 8 households can report that they've lost income, and that can adjust their rental obligation down. Section 8 tenants are also, due to their financial eligibility for housing, eligible for Medi-Cal programs. They're eligible for general assistance programs in most cases, and a number of other financial protections. But one of the things that wasn't contemplated that I think is worth giving pause to on this request is the fact that if you lose a Section 8 tenancy for any reason, you can be prohibited from getting back into the Section 8 program for a very long period of time. Most wait lists are closed or extremely long. And it seems when you think about the amount of rent a Section 8 tenant pays, and I know you know, Mr. Mayor, as our representative to the county, the Housing Authority of Alameda County, the fact that there's going to be all these administrative burdens related to households that staff at the Housing Authority are going to have to process, it seems like we could protect tenants who are Section 8 in our city at a very low rental cost if in the end they actually do require assistance. And so what I'd like to propose on this particular request is that we simply ask staff to amend the guidance here that says that on the one page on special restrictions that Section 8 tenants whose rental rate is based on their household would be ineligible, to simply instead either create an intermediary category or a different box here that says Section 8 tenants may apply and be eligible at the judgment of the provider or the administering or implementing entity that we select, simply so that they can review, do a check with them, have you actually requested a rental increase, did it get approved, so that if there isn't a barrier, we don't necessarily need to approve it, but if there isn't, we don't put someone at risk of losing their housing. That would be my first suggestion. On the issue of rents that are due before March 19th, this is a tricky situation. A lot of landlords do carry small amounts of rent over from month to month and hold it kind of out over the tenant's head as you still owe me this without ever going to collect for it. And I would like to say that we, instead of prohibiting this, we could give flexibility, which is the landlord could sign a release that's releasing the tenant of all prior rents due that were unpaid before March 19th in exchange for the rental assistance. So I'd like to give the program provider the flexibility to at least negotiate or offer the opportunity to the landlord to say the tenant isn't eligible for that $100 from a prior month that they still owe you, but if you agree to waive it in writing here, we would be able to provide you the rental assistance for these other months. And I think some landlords would consider that. And then other than that, I appreciate the comments that have been made in writing to us about the difference between actual and maximum affordable rent. But at this time, the challenge I see in trying to assist as many people as possible is that we really need to stick with the maximum affordable rent, actual rent difference. And that's I don't think going to be in multi-occupant households. I don't think it's going to be as much of a problem as some are concerned about in Emeryville, but I appreciate that concern being raised. And then with that, Mr. Mayor, since you're going to go to policy item 2, I just would lend my support to 2B first, simply because I think there are going to be some people who don't lose their housing before April 1st, or don't lose their job before April 1st, but who will have lost it subsequent to that, who should have an opportunity to get rental assistance for the month of May. Thank you for the time to comment.
You're welcome. And I think those are great suggestions. Member Donahue?
Just my inclination is that, to think about who is not going to get unemployment as being a major component of who really is going to need it. Like the gig workers just are not going to be able to collect unemployment. And they are most vulnerable other than maybe some Section 8 housing people.
Thank you. Member Medina?
Yeah, I also agree with 2B in terms of disbursement, because you don't want people to have missed the boat and then find themselves in an extremely poor position. And yeah, I agree with Member Donahue. I think in implementation, we need to look at what other benefits people are getting if they are eligible for the full maximum $1,050 a week and unemployment, federal and state, perhaps tying that to a lower proportional payout. But I'd like to give the authority to the city staff to figure that out. I'm really impressed with the program proposal pulled together here tonight. I think it's extremely thorough for something that's had to be done super quickly, and so I want to thank everyone for their effort.
Yeah, thank you. Martinez?
Yeah, I want to appreciate staff as well. This was an incredible thing to put together in such a short amount of time under duress and strange working circumstances. And I'm also in support of 2B because I think that as time goes on, people will have it hard in that first month, and some folks will have it even harder in that next month. So to be able to spread that out for those most in need, I think is important.
Great, thank you. So I'm going to shape my comments around the comments that you guys have all made, and I guess I should start with appreciating staff. Throwing this together so quickly is quite impressive. And I think as we look at this and we go through the policy questions and we talk about the changes that Member Bowders is suggesting, this is a stopgap measure. This is not solving for more than 1, maybe 2 months of rent for people who are likely to be out of work for a period of time. So when we talk about gig workers who are not able to quite access the things that the state and the feds are putting in place, or even people who are eligible for unemployment, both at the state and the local level, and my experience with this, I can tell you, comes from Member Medina talking to me about how we navigate these systems in place. Just because people are eligible for these funds and these things are being put into place, we are seeing that being able to access the money that has been allocated is going to be a big challenge. And so to me, the value of this program is not throwing a wide net, not throwing a life preserver to a lot of people, but really helping a chunk of people get past these first few months while all these programs and all these monies that are being allocated are figured out here in Emeryville. And so I'm very thankful of that, and also want to be very thoughtful on that. I feel that way about the Section 8. While I agree that they are the most vulnerable, and I will know the meeting happens to be tomorrow, and I know this will be one of the topics of discussion of, Section 8 pays a percentage of their income into the rent, and then the voucher covers the rest up to the caps. And so there is some protections and some things there, but I agree with what Member Bowders said, that once they're out, there is no getting back in under current federal mood. That program is being starved. We have some decisions to make. I think we can come back around to the things that Member Bowders is recommending, because I think those will get adopted in his motion. But I heard an overwhelming support that we do half and half, so that is on 2B. And so really quickly, unless you feel strongly for 2A, I think we can move to policy decision 1. If we feel strongly about 2A and want to speak on that. If not, will you move to screen for policy decision 1? And so this is the options we have. Now we're talking less than $200,000. So, 100 people. And so how are we going to determine which of those 100 people? And so I'd like to hear your thoughts on this, Member Bowders.
I support strongly option 1B to apply it first to people with the lowest income levels as priority.
Okay. Member Donahue?
Yeah, I agree.
Member Medina?
Yeah, 1B, absolutely.
And Vice Mayor?
Agreed.
And I think that helps us resolve some of the other questions. I'm not so sure that yeah, I think that 1B is the option. And I think that answers a lot of the other questions. So with that, I feel like staff have enough direction from us on these two items.
Yes, I do. Thank you.
Okay. And then, Member Bowders, would you do me a favor and restate your changes to make sure that those have been captured properly and that the other council members understand them, and then make a motion?
Sure, Mr. Mayor. Would you like me to do one at a time in case there's discussion or disagreement on each of them, or just collectively?
You know, I think do them collectively, and then when we come back out after your motion in that second, we can have more discussion. I think we're all on board.
Thank you, Mr. Mayor. At the bottom of page 1 of the program guidelines as attached to the staff report, there's a section titled Special Restrictions that says the following tenants and landlords are ineligible to participate in the program. The first one says Section 8 tenants. My proposal is that we give staff the direction to come up with language that would remove Section 8 tenants from ineligible to participate in the program, and instead state that Section 8 tenants are eligible to participate in the program, but will receive counseling and review from the provider to identify need, so that it's not, if they can benefit from a rent adjustment first, they can have that if that's possible to reduce any obligation. So not to put them in that category. Second would be on the restriction for people who only have, trying to find what page it's on here, sorry. There's the section that says the current on the rent. So under applicant, yeah, thank you. On the first page under applicant applicability or eligibility, the third check mark, tenant is current on the rental payment. That can remain there, but I would add a second check that says a tenant who is not current on a rent payment may still be eligible, provided the landlord agrees to enter into an agreement waiving all prior rents in exchange for acceptance of assistance for rents due and owing subsequent to March 19th. So that we have, we're actually providing another level of protection for those tenants by helping them potentially have their past rents waived in order to be eligible. Then the third item, well, I think that was it. I think those are my two items.
Okay.
Did I have a third item? No, I don't think so.
Okay. Staff, were you able to capture that?
Yeah, we got that. Thank
yes.
you.
Thank you.
Okay. And so, Member Bowders, I'm sorry, any member of the council have any questions or disagreement with that before I go back to Member Bowders for a motion, or to anybody who wants to make a motion? Okay, Member Bowders, if you're not on mute, go ahead and make a motion.
Thank you, Member Pats. I will make a motion to approve this program and to give staff the guidance and direction as just discussed related to those two programmatic changes.
Great, thank you. And I'll go ahead and second that in the interest of time. And so could we get a roll call vote, please?
Councilmember Bowders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats?
Aye. Okay, that brings us to 12.3. I feel like we have all read these letters. Do we need presentation?
Waive it.
I'm going to say waive it as well. Okay, so with that, I'm going to make a motion to, or I'm just going to say we're going to waive presentation and go right to public comment on this item.
I have none.
Okay, and with that, I will look for a motion from anyone to approve.
I would actually, this is my...
Oh, go ahead. Go ahead, Member Medina.
You're Christine.
Go ahead, Councilmember. Sorry.
I was going to suggest we pull the letter to Newsom about property tax deferment because our Alameda County Treasurer Tax Collector, Hank Levy, really proactively announced a plan to work with taxpayers and waive delinquent fees, which I think largely shows a lot of leadership from our regional elected officials and takes care of the problem here locally. I would recommend we go ahead with a letter to Commissioner Lara since there's been no movement out of that office.
I'll second if that's
Okay.
a motion.
So my only comment on this is just because we're proactive here, do we not want to lend our voice for other people across the state?
Frankly, the governor has indicated he is not going to do a deferment.
Mr. Mayor, I would also just note that the property taxes, by them coming in, the city is due to pay a large sum from the budget for the bond obligation we have from the redevelopment agency in the city, and we do not want to be in a situation where we're having to borrow money from the general fund to cover that. So we would like to encourage people to pay, and I think Councilmember Medina has been doing a great job leading on this, and her awareness about this is, I think she's on point with it.
Okay.
I would actually like to note that there's more protection at the local level, and I'm happy to repost what Treasurer Levy has offered. But basically, he's happy to sit down and work with people to create payment plans, as well as waiving those fees. That will help us as a city get more of those property taxes in.
Okay, I appreciate that. City Manager, Christine, did you want to make a comment?
No, thank you.
No, thank you. Okay. And with that, I will go back to your motion, Member Medina,
Yeah, that's my motion.
to approve just the second letter, the one to Commissioner Lara.
Correct.
Okay. And Member Martinez, I heard a second from you, correct?
Yes, that's correct. And Member Medina is 100% right. The governor punted on this issue back to the counties, and we have good representation on that level. So thank you. Second.
All right. And with that, we'll do a roll call vote.
Councilmember Bouders?
Aye.
Councilmember Donahue?
Aye.
Councilmember Medina?
Aye.
Vice Mayor Martinez?
Aye.
And Mayor Pats?
Aye. Okay, 12.4.
Hello?
Is that me?
I thought the call dropped. This was an
Okay,
item
do we
that
have a
was put
presentation?
on under future agenda items by Councilmember Medina.
Oh, yeah.
So-
Diplomatically, I'm going to suggest we continue this item.
Okay. With that, do I hear, is everybody okay if we continue this item?
second that.
Do you need to vote on that, City Clerk?
Mr. Mayor, as a courtesy, I think you technically still need to take public comment before we vote.
Oh, okay. So do we have any public comment on this item?
I have not received any public comment.
Okay. And did you need us to vote on this?
No, but was there a date in mind or just to a future agenda?
To a future agenda, I will work with the city manager to determine the appropriate one and continue to coordinate with respective stakeholders.
Thank you.
Yeah.
Excellent. Okay. That brings us to department head reports. Are there any department head reports this evening?
Mr. Mayor, did you want to have us address the item that you'd held over and tabled till the end of the meeting?
Oh, thank you, yes. What item number was that again?
11.3.
Thank you.
I think
So we're
Charlie
back to
might have a report
11.3.
out on that.
Yeah, Mr. Mayor, this is Charlie.
Go ahead.
The two speakers actually have raised enough questions that are going to require some additional research that we are just not able to conduct right here on the spot, that we would recommend that you continue this item to a future meeting.
All right, so I think we'll do that, or I'll recommend doing that. We continue this to a future meeting to be determined by Mr. Bryant. Is everybody okay with that?
Yes.
Yes.
Okay. And so with that, is that good enough for you, City Clerk?
It's good enough for me.
Perfect. Now we'll go to department head reports. And so we're back to you, Mr. Bryant.
Well, yes, as you can see from your agenda, the March 26th Planning Commission meeting was canceled, and all items have been rescheduled for the April 23rd meeting. The meeting is going ahead. We just published the agenda. It'll be published in the Tribune this coming Friday and mailed to folks. So all those items will be on the April 23rd meeting.
Okay. Do we have any other department head reports, City Manager?
I don't believe we do.
So I'm going to take a moment here and say that your community services departments, between their online rec and the work they're doing for our seniors, I would love to hear it out, but I'm just going to praise them surreptitiously through this method here and say excellent job, you and all the city staff who are really stepping up to help keep people going at this time, particularly our seniors. So thank you for that.
We will pass that along.
Yeah. From there, I go to future agenda item requests from council members.
Mr. Mayor, I have
Starting
two.
with Member Donahue. Oh, sorry. Perfect, Mr. Butters. You're up first alphabetically.
Okay, thank you. I have two. I would just ask that the council, just to reaffirm, that the council is going to bring back an urgency ordinance at the next meeting to go alongside the ordinance we just passed at first reading in 10.5 so that we have that in place immediately. And my second, I'll stop and see if there's support. Sorry.
Support? Everybody else support?
Yep.
Yes.
Yes.
That's your three votes, so go ahead.
Okay, thank you. And the second item, Mr. Mayor, is to have an action item on the next agenda that would amend the tenant protection ordinance for the limited purpose of defining exempted properties under that ordinance.
Okay, is everybody in support of that?
Yes.
Yes.
Yep.
Okay,
Thank
that
you.
gives you all four, just like the last one. Okay, did staff capture both of those?
Yes.
Great. Member Donahue.
Given that our retail environment is not looking so good, and our city's budget is definitely going to be different than we had been expecting. I would ask that the Budget Advisory Committee look at our business license tax and see what they think about that tax. Would they, compare it to other districts and what we currently have, whether there's anything we need to consider given our future budget.
Scott, would you accept the friendly amendment to that request to ask it go to budget and governance instead?
That's what he said.
Okay, yes.
He said budget advisory, and that's the resident
Budget
committee.
advisor. I meant budget and governance.
Oh, I apologize. You're okay. Perfect. Vice Mayor Medina, you support that?
I am not the vice mayor.
I'm sorry, Vice Mayor Martinez. I have a cheat sheet in front of me and I messed it up.
Yes, we support that.
Okay, perfect. Great. Any other requests, Member Donahue?
No, that's it.
Okay.
Oh, wait, I did have an issue that I wanted to consider about our immediate safety concerns having to do with elevators. You know, we have elevators, like, for example, at the train station, that are a likely disease transfer point. And I just think that we should look at our elevator design for having ventilation so that when you're in an elevator, the air is dropping down from the ceiling to the floor. And I just think that all elevators in the future should probably have that in our city, but I want that to be thought about in our city going forward as a part of our built environment.
So you're looking for a building code change? Is that what I'm hearing?
Yes, something like that, because I think it's a safety issue that we could relatively cheaply deal with. That you know, and I even see it as a future issue. You know, if we're going to have more pandemics or just resist colds and flus in general in the future, that all elevators should have their ventilation designed so that they're in effect structurally like clean rooms where the air just drifts down from the top. And I just think our public health would go up. We'd be able to have people riding in an elevator not contributing to disease transfer nearly as much if we just had this. And, you know, thinking about the smell elevators that we have at the train station, the smell reduction could be significant also. So if we had, you know, a little bit of positive pressure at the top and a negative pressure at the bottom of the elevator, that would go a long way.
I think that's. So my thought was, and then I'll come to you, City Manager. My thought was that might be something, because I think a lot of the building codes around the elevators are done at the state level, that maybe it's a conversation with you and Mr. Bryant, and then bring it back if we need to have the Planning Commission. But I don't know how much leeway we have there. And coming to you, City Manager.
Thank you. And Councilmember Donahue, I just wanted to reflect, I had passed along your comments to the Public Works Director with regard to our existing elevators, and she is connecting with our elevator companies to explore those ideas with regard to the current elevators that the city operates. So in addition to the mayor's idea in terms of connecting with community development, we also are looking at it for our own existing elevators.
Does that work for now, Member Donahue?
Yes.
Okay, great. Mr. Bryant, you've got that?
Yes, I do. Thank you.
Okay, excellent. Okay. Member Medina?
Yeah, I would love it if staff could come back with a report on ways we can make our public spaces safer during the social distancing era. Specifically, potentially opening up streets. I understand there could be a lot of complications with opening up a street, but I am surfacing it as a thing I think would be good, especially on Doyle between 61st and the beginning of the Greenway, where there's so many runners and walkers in the evenings. It's difficult to maintain 6 feet of social distance. I am open to other spaces as well where people have been tending to use the public sidewalks and finding that those narrow sidewalks are insufficient. In addition, suggesting that we consider redoing whatever we need for single timing algorithms so that we don't need pedestrians to press buttons, and maybe putting some stickers up saying do not press these buttons to further reduce transmission.
I support that.
Are you looking for that at the next meeting, or?
Mr. Mayor, if I could just jump in. With regard to the second item, we'll be reporting we'll be giving you some a new program that we're implementing. We'll report on that on Thursday at the Public Works and Transportation Committee. So I don't think that one's going to need to be scheduled. And then with the first one, if you could refer that to the Public Works and Transportation Committee, I think that would be terrific.
Great. I would like to refer to the first one about open streets, public works, and transportation. Happy to pull the second. So glad to hear I'm going to get an update soon. Thank you.
Support.
Support. Okay. That brings me to the Vice Mayor.
Thank you, Mr. Mayor. So council, you may be in receipt of a letter from Waste Management where they cite force majeure to get out of some of their responsibilities in terms of recycling and other things that are pointed out in their contract. So I'm asking for staff to bring back an information item upon the response of Waste Management to a letter sent from Nancy Humphrey, basically telling them you can't do this without backing up all of your statements and what is the exact impact of COVID-19 on your diversion. So asking for an information item, I just want to make sure that we keep track of this and that they know that we're aware of what they're doing.
Support.
Support. Support.
Support.
Mr. Mayor, we'll be
Okay.
prepared with that item for April 21st.
Excellent. Okay, that brings it to me for future agenda requests, and I don't have any. And I'm going to keep you all here for one moment longer. I just want to take a moment as we end our meeting all safely in our homes, that so many people who have been deemed essential don't have that luxury and are forced out into the work world. And even this evening, I know our city clerk had to go into the office, and Dave, our videographer, is there at City Hall. And, you know, we just can't overlook how important the people are when we deem their work essential, and they have to keep going to work, not to mention healthcare workers and others on the front line. So I just want to end by thanking all of them in this time. And with that, it is 10:21, and we are adjourned.